Yes. Hmm.
Possible item number 12.
Good. Yes, Mr. Tripathi, in development manner, we have had a winner not yet rescued. These are after 2111, we have done this. Mm. Bengal is now major, man. And their family members, so the guy's family member, they have no objection here that if the girl marries the boy, so what is the problem now?
सर ସେମାନେ ଆକ୍ୟୁଜ ର ଯୋଉ ଫାଦର ସେ ଟିକେ ସାର୍ କୋଅପରେଟ କରୁନି ଆଉ ତାର ଆମେ ଦୁଇ ତିନି ଥର ମୁଁ ବି ତାର ମଦର କୁ ବହୁତ କନଭିନ୍ସ କଲି ସେ କହୁଛନ୍ତି ଆମେ ଜାଣିନୁ ବୋଲି ସେ କହୁଛନ୍ତି
Application,
ହେଇଛନ୍ତି ସାର୍ ସେମାନେ ବେଲ୍ ହେଇଛନ୍ତି ସାର୍ ପାର୍ଟିସିପେଟରୀ ଫାଇଲ କରିଥିଲା ତାପରେ ପୁଣି ସେଟା ୱିଡ୍ର କରିଦେଇଛି ସାର୍
Okay.
ସାର୍
So now there's participatory wall application pending before this court. What is the status of that particular case? Of that case case number 95, dated 22 to 2022. What is the status of the charge sheet submitted or it is still under investigation?
under investigation.
Under investigation. Here, please. Have you taken steps for against the accused for under 82 and 83 CRPC?
Yes, sir.
Why? It can be taken during course of investigation also if the accused is found absconding. You can take that step, you can pay for before the court proclamation.
Sir.
The war procedure have been laid down So, in spite of your sincere attempt, as your case does, it shows that the boy is absconding. Now, the provisions are there. You must apply your mind and make necessary application before the concerned court to take steps in that regard. But a proclamation ହେଇଗଲେ ତାର advantage ଟା ଆପଣଙ୍କୁ ମିଳିବ। ଏଗୁଡା କଣ ଆପଣ ସବୁ ବୁଝେଇବାକୁ ପଡିବ 82, 83 CRPC ରେ have you not ever taken any steps at any point of time during the course of your entire career? So you have taken. So once that is issued, then it may be successful. So it's not that somebody should advise you in that regard. Whatever options are available with you, take that. What is the offense now? 363. So it's a double offense.
So,
The punishment is prescribed under section 363 is for 7 years, but it is a double offense. But it is a cognizant, so you can arrest without warrant. But that is how the power is conferred on you. And before taking a recourse to section 82 and 83 CRPC, then you have to file appropriate application making all the details that these steps have been taken and in spite of that, the person is absconding. So the almost so fast. Counsel for the petitioner is not there. That day he was in BC Mela. The doctor was in BC that day. And today is not present. We asked him that it will be taken up on Thursday. So, you took, you have sought for ultimately time. For giving you some time, you feel. This matter came last time on 6/11/2023, or thereafter it came. 2011. 2011. 2011. Sabrasti, 5/12/2020. Proclamation state meaning to upon.
NBW by लिखी सर तब
Now, if you go through the provision, it is so that it is true to him. Mr. Patil, I'm just showing. If any court has reason to believe whether after taking evidence or not, that any person against whom warrant has been issued, it has absconded or is concealing so that such warrant cannot be executed, such court may publish so and so. So whatever steps have to be done in section 82, you have to do it. Right? Then you can take also for the attachment of the property, if any property is available, that is under 83. If that includes also the bank, because property definition is very broad. So you can also, that instruction can be given so that he cannot operate also if any account is there, any property is there. So once you put pressure in that way, you can succeed. That you have already given assurance that that their both the family members are the girl's family members have no objection now. They are ready to give their daughter marriage to this accused, and the girl is measure because the boy is too.
It's a tent house, sir. Tent house.
Tent house.
Sir.
So
father भी tent house अच्छी. Picture अच्छी.
Only son.
3 sons, sir.
3 sons. Sir. Okay.
He's the elder one, sir.
So keep in mind this provision and take appropriate steps. Otherwise, if proclamation is issued without complying with provision, that will be set aside. So all these things to be kept in mind.
Sir.
Okay, in accordance with law, you have got the experience, do it, and I will appropriate. Let us see if any fruitful result come out or not.
Sure. କାଲି ବି ସାର୍ ଆମକୁ ଗୋଟେ ଇନଫର୍ମେସନ ମିଳିଲା ଗୋଟେ ଜଙ୍ଗଲ ଗାଁରେ ସେ ଅଛି କାଲି ବି ଆମେ ଯାଇଥିଲୁ ସାର୍ ଗାଁରେ ସେଇ ଗାଁରେ 3ଟା ନାଁ ଆସିଲା ଗୋଟେ ପଡା ଥାନାରେ 2ଟା ଗାଁ ଆସିଲା ସେଇଭଳିଆ ସେଇ ସାଟିଆ ପଲ୍ଲୀ ବୋଲି କହିଛି ତ କଣ୍ଟିଲ ଫାଣ୍ଡି ଅଣ୍ଡରରେ ଗୋଟେ ଥିଲା ସାର୍ ଜଣା ପଡିଲା ସାର୍ ତାଙ୍କର ରିଲେଟିଭ
ଦେଖିଛନ୍ତି some information ଯୋଉ ଜାଗାକୁ ଆପଣ ଭାବୁଛନ୍ତି ତ ସେମାନେ ସକ୍ସେସ୍ କରିପାରନ୍ତି ବଟ୍ ଆସିଥିଲେ କି ନାହିଁ some clue about that.
ଆଉ ଗୋଟେ ଇନଫର୍ମେସନ ଥିଲା ଯେ ସେ ପୁଅ ଆସିଥିଲେ କୋର୍ଟ ମ୍ୟାରେଜ ପାଇଁ ସାର୍ କପଡାକୁ ଆଡଭୋକେଟ ସହିତ ମିଶିବା ପାଇଁ ତ ଆମେ ସେଇଟା ମଧ୍ୟ ସାର୍ ଭେରିଫାଇ କଲୁ ରେଜିଷ୍ଟର ଅଫିସରେ କିଛି ଆପ୍ଲାଏ ନାଇଁ ସାର୍ ଆପ୍ଲାଏ କରିନି ସାର୍ କିନ୍ତୁ ଆଡଭୋକେଟ କୁ ମିଶିବାଟା ଆସିଥିଲା ବୋଲି ଖବର ସେ କୋଅପରେଟ କରୁନାହାନ୍ତି ସୁଇଚ୍ ଅଫ୍ କରିଦେଲେ ମୋବାଇଲ
advocate means they will apply before the sub-register. So also give information to them if any such application is made. Immediately communication is to be made to you. Because now the law is not got any kind of protection from this court, right? Because he has filed anticipatory bail application, it has been withdrawn, right? So there is no problem for you to arrest the accused. Only thing is that whatever steps you have to do, that should be in accordance with law. And there are provisions also which you have not yet availed. So you try to do it, take steps. We are keeping this matter in February, and as per the order dated 2011-2023, Mr. Abhimanyu Das, Inspector in charge at Hon'BLE Police Station, Bhubaneswar, UPD, is present, and he has filed the status report, which is taken on record. The status report indicates various steps taken by you are the investigating officer, no? He will also be investigating officer level for tracing out the victims, also for the arrest of the accused. The status report is taken on record. The investigating officer submits that some further steps are likely to be taken up very soon in accordance with law, and some more time be granted. Now appears for the petitioner to of this matter in the actually so MBWC करिए तापर हाँ investigating अपना let it be on 26th February. Okay, we commencing from 26th February 2024. Give those data so that when your application should also tally the case by case. ଆପଣ କୋଉଠି ଆମେ search କଲେ that should get correlation from the case diary so that because there is likelihood that they will challenge it. So all these things have to be kept in mind. Yes. I will hit tables like that. Copy of the order. I will see on that. You personal appearance dispense with for the Rankali. If it would be necessary, we'll see that.
I think
Yes, item number 15. Mr. Jafrullah. We are not rescued till date. मेथड देखिए 12 नंबर ना अच्छा अच्छा तो आंसर shall remain present same time. Mr. Das, you must be aware that yesterday some order has been passed over regarding this personal application. Yes, sir. So there some kind of restriction is there, but that's why we ask you to take proper instruction. Otherwise, you will be compelled to write that the state council is unable to write that. Right. Okay. But my remember in this investigation, nobody's gone through that. I've gone through some now. We will go through detail in that matter. What has been printed in the print and electronics media that, but it has to be carefully gone into. So, yes. Because my lord cannot, as per the guidelines SOP, there's some restrictions. No, you can ask him to appear to virtual mode. We can also have officer with that you can, in that there is no objection. Yes, but we will not write it. Yes, we will do one. You can, for assisting in court, you can always do that. Otherwise, if necessary, you can through virtual mode, you can appear. But please carefully, when both of us will go also through that unnecessarily, nobody is calling them unnecessarily. It's required for the requirement for this. So now, Madam, what you have done in this case?
Sir, after registration of this case, very promptly we have examined the complaint and their family members. We visited the spot and also examined the local witnesses, and immediately we shared VHF message and confidentially we shared the photographs of accused and victim in our police group for early rescue. We also
victim girl, you have also mentioned victim girl is only 14 years.
Sir.
She was prosecuting her study in the school.
Sir.
Which class?
Sir, class 9 now. She has to appear. And prior to that, she allowed to that boy.
It's all right. The immature mind, anything can happen. That boy's name is Dwayne Binay.
Sir, the boy was residing with the victim in same house. They are neighbors and they are having very good relationship prior to the elopement.
But you see, the date of birth is 19/4/2009.
Sir.
That means she has completed 14 years of age. By now, running 15. Right. At the time of occurrence, she was 14 years.
Sir.
So,
we had also obtained the CDR in the location of the suspect numbers. It was in Gurgaon. While we were trying to move for Gurgaon, the number suddenly got switched off, and from 2 to 3 days prior to the switch off, she called his father and told that, Papa, do not come, I am just leaving Gurgaon for home.
That girl had communication with
the parents.
Okay.
That I am leaving Gurgaon and reaching home within 3 days. Do not come here, and I am just thinking about you. But sir, that was a pre-planned communication between the parents and the victim. While we were about to leave Basdepur, they made it, and ultimately we stopped thinking that they are coming. So they switched off that cell number, and now we are unable to get the new number, and they are not using, and the IMI report is nil.
Thereafter, there is no contact with the parents.
That's it. And sir, in this connection, the father of principal accused also forwarded, sir. He has got interim protection from this court, from honorable court, that he will not be arrested along with his wife. He showed the documents in front of public, in front of the house of victim, that I have got this and no one can help me. Then in this connection, there was a quarrel, And also, though there was no outraging, but the mother of the victim has mentioned that he outraged the modesty and just threatening to kill us. In this context,
If he is flouting the terms and conditions of the law, then recourse is available with you to file an application for cancellation of that interim protection.
sir, we move.
That you can do.
Sir.
After getting such interim protection, if he goes to the house of the victim and shows it and makes all kinds of these nefarious activities, the option is available with you.
Sir, was in front of public. You to the house of victims.
It ultimately creates a hate in the mind of the persons.
Sir.
The public will go and tell that he has obtained an order, so nobody can touch him. That is not the thing.
Sir, he was forwarded, sir. In another case, in an case registered, sir, and he got forwarded.
Then it's all right also. Since when you are unable to get anything, maybe from the parents, maybe from the other sources, that thing happened when that Gurgaon incident you said, when that took place?
Sir, prior to a month, sir.
Prior to a month.
Sir, the complaint himself, sir, proceeded to us and denied to move, sir. That my girl is coming, we need not to go there. We're just making tickets, sir. But 15 to.
No, I'm sure that having verified that any such call came from.
Yes, sir. That was call and the call was recorded, sir, by the complaint, sir.
Okay. So we granting time we are doing only this, but just keep in mind that the girl is 14, 15 years and what is the education of that boy who was kidnapped that
Doing nothing, sir. He's the main person, sir. His father has a grocery shop, sir.
Not.
He's a major, sir.
He's not married.
Not married, sir.
So, Mr. Das, we are granting you marriage.
I was complaining his father on that call record. I was just getting that you please withdraw the case from the court.
Sorry, but her career has been spoiled because she's just prosecuting her studies. She didn't is not understanding what will happen in the future. This is just this teenager thing Please write your name, the relationship of so and so is present as per the order dated. There is no order support. But government counting for this one so sometimes. Actually, this is the last time. As well. 5 ପରେ 18 ଥିଲା 18 ତ କିଛି ନଥିଲା ମାନେ ସେମିତି ଲିଷ୍ଟ ହେଲାନି Right, so and so is present and she has submitted the status report, which is taken into account. The status report indicates various steps taken for tracing out the victim and for arrest of the accused. We are satisfied with the steps taken by the officer, and since he is asking for some further time to make necessary attempt further attempts for tracing out the victim and to carry forward her investigation. of this matter will be commencing from 26th February 2024. So, two copy of the order we handed over. This is taken on record for them. So, we are keeping it on 26th February 2024. Prior to that, contact, and if it is necessary, if he requires your presence, you come. Otherwise, you appear through virtual mode on that day. Okay. Yes, Lord. Yes, Lord. Direction. Yes, item number 17. Yes. It also arises out of the same police station. That's yes. And what is the age of the girl?
Yes, sir, now 16 plus, sir.
16 plus.
Sir.
And FR is against named person.
Sir, yes, sir, both the victim girl and the FR named accused are neighbors, sir, are immediate neighbors. They fall in love, so they left, sir.
And what that girl was doing?
And girl was studying, sir.
Okay.
+2.
Plus?
No, +2, sir.
And what that boy is doing?
Boys are doing nothing, sir, just to have a sweet stall, sir, in the local market. Sir, both have not taken mobile phones, sir. But the numbers of relatives of the accused have called for, but no fruitful result we got from that. Demand.
The boys measure.
Boys measures. No. What about patient? What is it?
Application has been for this court anticipatory or on application for by the accused or by any court. At least case they will be called for in connection with this.
Yes, Dave, sir.
Any information you have received at most?
The informant of mother of the victim, information that accused is at the local, they are staying at locality. The Bhadrak, they are staying near the Bhadrak.
Usually we found any food.
Sir, that was very good. They told that in Agarpada, but they failed to Agarpada, Bhadrak, but they failed to identify that place. We have been to there, sir. It was near a hotel, but nobody was there.
So if you give any concrete information, supply to the madam so that she can do the needful. But don't just any kind of information if you give and that will be wasting of time. They have other words also. So if any authentic information you give, then just communicate so that they can verify. And
the father of the accused are doing job at a hotel at Agarpada manor.
That has already verified this.
Sentimental manor.
It's all right, that has been verified and it is found. Not there.
Sir, I am in regular touch with the sister of victim, sir. Sir, I am in regular contact with the sister of victim girl for latest information. That was the latest information, sir.
You are right from the beginning. You are the investigating officer.
No, sir, I served at police station supposed to another
She's investigating.
so,
Because the words have been used as he. So I thought that why it has been used like that.
Sir, Vijay Das Mahapatra.
Okay, that's all right. Also. In paragraph 7, which you have mentioned, that raid has been conducted in the relatives' house at different places. So for that, necessary entries are there in the case diary.
Sir, corroborated, sir, that's the case diary.
None of your family members have received any kind of communication from the victim girl. Both are neighbors.
Both are neighbors.
All right. Similar order pass कर देंगे, but it is the appearing कर दें. Same date रख देंगे. Free copy of the order is handed over. Status report furnished and all right. From that we are keeping all this. Okay. 26 to 27. Mr. Das, hand over a copy of the status report. Yeah. Yes. No, yes. Then in this dismissal, it has a organized like personal appearance. It's a 302 case. Sole appellant or sole migrant. Please come to the fact. Plus 20, 20 plus 20, 20. Please place it. Yeah. माननीय संयुक्त सदस्य भागवत अफिसर महोदय सदस्य महाशय निवेदन की आंदोलन व्यक्त कर श्री दास Chandra Das is PW to Anil. Yes. Brother of the deceased winner. Boss is IC. Just a minute. What do you mean? Deceased? Deceased IUS. BB. BB. IUS. Padmavati Mahalik. One. Yes, please continue. पिता बाइल दास साकिन आखर साई पोस्ट गेंगुटी थाना सदर जिला बालेश्वर जनाऊँच कि मोर भौणी विधि को आज 20 वर्ष तले बुईता ग्रामर श्री जगमहाली जगमहाली की पिता गुरुप्रसाद महालिक को विवाह होइथिला समय तांकर छुआ पिला धरी 6-7 मास हेबो साम पदारे घर कर ସେମାନେ रही आसुथिले आज ता 5/5/2005 तारीख सकाळ 6 घटिका समय आम्बे खबर पाई साम पदा को आसी देखिलु
ଆମର ଭଉଣୀ ବିବି ମରି ପଡିଅଛି, ତା ମୁଣ୍ଡରେ କୋଦାଳରେ କ୍ଷତ ହୋଇଛି, କୋଦାଳଟି ସେଠାରେ ପଡିଅଛି। ମୋ ଭଉଣୀ ରକ୍ତରେ ଚୁଡ଼ି ମରି ପଡିଅଛି। ଜଗନ୍ନାଥ ବାରମ୍ବାର ଭଉଣୀକୁ ପିଟାମରା କରି ଆସୁଥିଲା। ସେ ଗତ ତା 4/5/2005 ରାତିରେ ତାକୁ ମାରି କୁଆଡେ ଫେରାର ହୋଇ ଯାଇଅଛି। ତେଣୁ ବିନୀତ ପ୍ରାର୍ଥନା କରିକି ୟାର ବିହିତ ତଦନ୍ତ ହେଲେ ଆମେ ଚିରପକୃତ ହେବୁ। Well, I think the son is the eyewitness, but he turned hostile later. Son has received an appellant, not submitted the prosecution case. Only part, that assault part is illegal. The rest part he was supported. Assault means part in when he wake up, he saw that his father was assaulting my mother. And thereafter he scolded him to sleep. This is the statement he made in 164. The subsequent details in that part he has already told. Night, there was a quarrel between the all three admitted. Okay, the trial took place remand from the evidence of PW5. PW5 and the supposed evidence witness matter, the reference witness what he was stated that he was present 15 days prior to that he had come to that spot. The place where the disease was residing. The body was found inside the so it was horrible. Pokuri room bahar bedroom one room pokuri nice room bahar so it. Oh, outside the house or outside the house? Outside the house dead body right. So spread tabitella. That was available. So anybody that means the son has seen the appellant on the previous night. Yes, sir. Found previous night and the appellant was found assaulting disease that he has 164 statement is there, but it's on 164 actually even on that same part also. That 5 other see the last scene who has seen him in that night, fateful night he has seen him. He had a little shop in front of the house. He has seen that accused was present on that night also. Where he was present? In the house, yes. Okay. And PW 3, 4, 6, and 12 they have seen. They stated that he was present prior to 15 days. Because previously he was staying in another place. There was a quarrel between relating the selling of the land. Where the deceased issues that who was assaulting him repeatedly. That was the statement of PW1 and others also. Thereafter he came back and he stayed in the house of the father. When he told me comment like they made a house and she was paid. Prior to that he has come there. This is Mr. Tripathi, on still that's a different matter. Evidence in the company of the deceased on the previous night. That was stated by PW5 the son, as well as PW3 the little owner. And in other evidence like extrajudicial confession, and second thing, he fled from that place and he apprehended after 1.5 years. Absconding and apprehended also. So motive is there. That is the more important thing in circumstantial evidence. They have property which you want to sell. Property like property is there. Accused and this is accused of it. He want to sell, but repeatedly he is refusing not to sell that. Who is refusing? Deceased मना करी कहानी मतलब that not how to say that the one concrete that is not the best record that he had landed properties which he wanted to dispose of. खाली कोई बोले ही थी तो हम
बाकी we see a motive external PW5. But if PW5 is like a vital weakness, if you let us come to that weakness first, page 43. Because the time here between marriage and the occurrence is 19 years. And they have only that son, PW5. 8 children. What about the other children? The 4 children stay with the father in the village where they stay. And one they studying baby and 3 children they with the including this PW5. Out of them, PW5 is exam. Yes, 13 years old boy, he has like that. So let us come to that PW5. Let us see what Chow has stated. Yes, please, PW5.
Page 43. ପ୍ରଶ୍ନ ଆଜି କିପରି ମଙ୍ଗଳବାର ମିଛ କହିଲେ ଭଲ ହେବ ନା ଖରାପ ଖରାପ ସପ୍ତାହଟା କେତେ ଦିନ 7 ଦିନ ଠିକ କରି କହିବେ answer after understanding the questions he is accused present in doc is my father this is Bibi alias Padmavati is my mother has died in village pakhara shun there was a quarreling between my father and mother. As a result, she came to village Pakarashunu and stayed there. Myself and my 3 younger sisters came with my mother and we stayed together. The house where my mother died was in village Pakarashunu. My mother died in the night. In the morning, I came to know about her death. I saw bleeding injury on the ear root of my mother. She did not respond to my call. So I went to call my maternal uncle Pidul1. I can say how my mother died as I slept in the night. I was examined by police.
So that means in chief she was totally not stated anything about the presence of the in cross examination after being declared hostile. I like to replace it.
Declared hostile and FPP is permitted to put leading questions. It is a fact that I have stated before the IO that on the occurrence morning and evening there was quarreling between my father and my mother. It is not a fact that I have stated before the IO that on the said night I woke up for passing urine when I saw the accused assaulted my mother by means of a spade, and when I shouted, the accused threatened me to assault, and out of fear I slept. It is a fact that I have stated before the IO that my father was absent in the house when I saw my mother died. I have given this statement before the magistrate earlier, which has been recorded under section 164 CRPC. I have not stated in my under section 164 CRPC statement that my father came on the morning on 4/5/2005 and went away. Exhibit 5 is the said statement with my signature. It is not a fact that I am deliberately suppressing the truth to save my father in the case. There is a cross-examination by SDC. When we came to village Pakarashuni, we first stayed in a house of my paternal uncle, Pidul1, as there was some discontentment. My mother left that house and lived separately. The house consisted of one room. There are no door on the side house. On the occurrence night, my mother has slept outside the house as it was a summer season. Stayed in the hut for about 15 days after leaving the house of Pidul1. My father had never gone to the house where we were staying. I have not disclosed that fact to anybody else. My 3 younger sisters are staying with Pidul1. They have been engaged Pidul1, engaged me in one place, but I left the house and now staying with my elder father in village Boita. My father had not gone to the hut on my mother on 4/5/2005.
So, Mr. Tripathi, the positive statement which he has come, that is that my father had not come to the house where we are staying, because they stayed 15 days prior to the, they were staying with PW1 as it appears. To PW1, they are staying separately. Stay separately from the accused. We staying for 3 days with PW1. You see, page 45, we stay for about 15 days after leaving the house of PW1. So that line is there. That means the place where the occurrence took place, at that point of place, they stayed just 15 days prior to the date of occurrence. Ask the state with PW1. Paternal uncle, ଯେତେବେଳେ ବିଷୟ ହେଲା ସିଏ ଶାଶୁଘର ଛାଡ଼ିକି ଆସିକି ରହିଲା PW1 ପାଖରେ ତା ମାମୁଁ ଭାଇ ଘରେ ଭାଇ ଫାଷ୍ଟ ଷ୍ଟେଟ୍ ମାନେ ସେଠୁ ଛାଡ଼ି ପାଖକୁ କାହିଁକି ଆସିଲା ନା ସେ କହିଦେଇଛି ପୋଷ୍ଟ ଇଏରେ କହିଛି then as he called you, there was quarrel between my father and my mother ceased. As a result of which she came to this Pakharswa and stayed there. Pakharswa PW1 Pakharela. Who is brother, who is the paternal uncle of this witness and brother of this deceased, right? Yes. But PW1 stated that he was staying separately. PW1, the informant, he stated that ସେଠୁ ଝଗଡା ହେଇକି ଆସିକି ଗୋଟେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଲ୍ୟାଣ୍ଡରେ ଗୋଟେ ଛୋଟ କୋଳି ଭାବି ଯୋଉ ଘଟଣା ଜାଗାକୁ we are not under the main thing ସିଏ କହୁଛି ଯେବେଠୁ ଆମେ ଆସିକି ରହିଲୁ ସେ ନୂଆ ଜାଗାରେ କଣ ନା ପାଖରେ ଶୁଣା ସେଠି ମୋ ବାପା କେବେ ବି ସେଠିକି ଆସିନି that is most influential. Let's kind of as to para to let's say. No, para to what you have stated, that is not the substantive piece of evidence. Police pakhare koichi, so magistrate pakhare koichi, all that, but the substantive evidence is that my father had never come. My father had come to the hut of my mother on date of occurrence. So specific statement has been made. 4-5 ରେ ବାପା ଆସିନଥିଲା କେବଳ 4-5 ପାଖାଶୁଆ ଗାଁରେ ଗୋଟେ ଘରେ ସେଇ ବାପା ଆସିନି ଏଇ ଷ୍ଟେଟମେଣ୍ଟ ଆସିଲା ଏବଂ ଚିଫ ଏକ୍ସାମିନେସନ ବାକି statements cannot be used as substantive purpose of 161 and 164 is for a particular purpose. We cannot use it as substantive evidence. So evidence goes. Then what is PW3 post occurrence without that amount is true. PW3 is present prior to 15 days in that place. PW1, let us come to that PW1. Seen the last night also, let's say. That is the father who becomes son husband. PW1. Please come to PW1. Yeah. PW1 page 29. I know the accused present in dock, who is my brother-in-law, sister's husband. He is my sister. I am an informant in this case. My sister Bibu was given in marriage to the present accused persons 19 years back. After the marriage, she was staying with her husband. My sister had 8 children. In the year 2005, my sister raised objection when accused tried to sell the landed property. The accused was doing no work. Thereafter, accused assaulted my sister, for which my sister came to our village, and there was a meeting in this regard. My sister stayed in a separate house near our village. Accused also came to staying with my sister about 15 days prior to her death in our village. This line is on the line, but okay, continue. In her marriage house, separate house. In her separate house. Accused also threatened my sister as to why she did not allow him to sell the land. Accused threatened my sister and one day prior to her death. On 5/5/2005, I came to know from my nephew Rabindra Malik
about the death of my sister.
He got running and had a 5 minute son of the PC. That broke him. Yes.
He disclosed before me in the morning that the accused has killed the deceased and had fled away from the house.
So this PW5 himself is not aware, so how can he? So this is getting a correlation because it's a now it will become a hearsay evidence.
Yes, sir.
Yes, right. Yes, because that PW5 has not stated to have disclosed before PW1 that accused had killed the deceased. So it is a hearsay evidence. Yes, next.
And I called the villagers and went to the house of the sister. I saw there was a bleeding injury on her parietal region near left ear. I have also seen that a cloth was tied in her neck. I have also seen injury on her back. By that time, the deceased died. I went to the PS and gave a report in writing. One Ananta Pradhan scribed the affair as per my instructions. It was read over and explained to me since it was corrected. I signed the affair, Exit 1. In the affair and Exit 1 by 1 is my signature on it. I was examined by police, cross-examination by SDC. When my sister was staying with the accused in his house, she gave her 2 daughters in marriage. Accused has joint property of 1.5 acres of land. I have not seen this document. I can't say the location of the sisters. The property is the name of father of the accused, brother of the father of the accused. To my knowledge, there is no landed property in the name of accused. There is no property in the name of my sister. Accused has sold some land. I can't say to whom he has sold the land or its extent. 6 months prior to separate residing of my sister, the accused assaulted her in her as she did not allow to sell the land. When my sister came to our village, 2 children were with the accused and the rest of the children came with my sister. Some son Ravindra and daughter Bonalata, aged about 15 and 17 years, were staying with the accused. My sister did not join the accused in the house of her in-laws after separation. The accused came to the house of the sister for the first time 8 days before her death. Yesterday, 8 days. Accused had not gone in those 80 days. It is not a fact that accused was a rickshaw puller. It is not a fact that accused was coming to Baleshwar for a pulling rickshaw. It is not a fact that accused was never visited the deceased in her separate house in any time. It is not a fact that accused was working in village Poladi when the deceased died. It is not a fact that on that day, death of accused deceased, accused was staying in his village Bhuta along with his son Gayadra and daughter Banalta. There was no wall on the house of the deceased, but all sides were covered by straw and polythene. There was no door. My villagers have seen the accused staying with my sister in our village. My sister has reported at the Hintapura police station about assault on her by the accused. The house where the deceased was staying is at a distance of more than quarter-mile of my house. House of Madhusudan Pradhan, Bhagwan Patra, Manodar Bhuya are also close to the house where my sister was staying. There was 15 to 20 shops near the house of the deceased. I was not present when accused threatened the deceased, but the deceased disclosed this fact before my wife. I heard it from my wife. I had not asked anything to the accused about the threatening. I had not gone to the house of the deceased one day prior to the occurrence or on the previous day of occurrence. Minati Malik, aunt was also present when my nephew disclosed about the death of a deceased. About 10 to 15 persons went to the spot. There was gathering of around 20 to 30 persons at the spot when we arrived there. I have seen both the arms of the deceased were broken and there was swelling. I have also seen blood in stain, injury on her back. The sari which was worn by the deceased was tied in her neck. Her wearing apparels were stained with blood. There is also blood stain on the earth. I got the affair scribed through Advocate Clerk Ananta Pradhan. I got it scribed through him in the morning as it was morning office. It was about 7:30 a.m. Intagara Malik also came with me when I got the affair scribed. The affair was not read over and explained to me. I signed the affair at the PS police came to our village about 8:30 a.m. or 9 a.m. on the very day. I was examined by police in the village. 9. It is not a fact that I have not stated before I was at prior to 2005 approved as the deceased as she was not willing to sell the land property. Sell the property. Who is that? Are you? Miller?
So,
PW.
PW, sorry. 7. Which confrontation have we made about the previous statement? Okay, it has been proved on page number 53, paragraph 8. Please read it out, page 53, paragraph 8. It is not a fact that the accused was staying in his house before or after the occurrence. I have examined Purnachandra Das PW1, this PW1, my first one. He has stated before me that the accused was threatening the deceased as he was not willing to sell the land, but he has not stated before me specifically that this threatening was before 2005. He has stated before me about this injury all over the body of the deceased, but he has not stated before me specifically that he saw injury on the back of the deceased. Now, Mr. Tripathi, you see, if we analyze the evidence of this PW1, that is knowledge than the deceased. So far as this motive part which you are having, it scales that the deceased was raised objection. The appellant wanted to dispose of some of the landed properties to which the deceased was raising objection, and that is the reason why there is dissension between the husband and the wife, right? Questions have been put in the cross-examination that he is not aware where these properties are there. He has not seen the documents, right? And more specifically, it has been brought that the accused is not having a separate property, but if that property is stands in the name of his father and uncle, his brothers of the father, that means paternal uncle. So in such a situation, if the property stands in the name of father of the accused and uncle of the accused, then because accused wanted to dispose it of, it cannot be done. So that unless specific evidence is there, that they have given all the authority to the accused to sell the property, or they have there is some kind of amicable settlement between parties that it would be accused can sell it. In that light, if the evidence is absent, how it will be accepted that it was the reason for this particular proof there was dissension between the husband and wife. Maybe not the legal property does not come alert, but there was a disagreement between the accused and deceased while saying so, let's say, because he was staying there for 19 years. And suddenly he came 6 months prior to the murder. You are assigning a particular reason. Yes, yes. Because the deceased is staying separately at another place, that does not mean that because of the dispute between husband and wife, the deceased came to reside at a separate place. There may be hundred of reasons. Say one of the reasons. See that how far that reason is acceptable or not. You have said that it was he wanted to dispose of the landed properties for which the objection was posted, and there was dissension, and that was told to another witness by the deceased man. That was also told to another witness by the deceased. Now, this is stated that the wife, these three, etc. It only stated that but another witness who was told that the deceased was telling that because of that she came back and stayed separate. Yes, and quite special. That apart, the statement of this PW1 is contradictory. In his examination in chief, turn page 29. Page 29, last sentence. Accused also came and stayed with my sister about 15 days prior to her death in our village. Then turn to page 31. During cross-examination, he is again saying, that is ninth line from the accused came to the house of my sister for the first time 8 days before her death. These statements are contradictory. Well, it is very difficult to remember. Immediately he forgot. But one thing, Mr. Tripathi, suppose the sister or the deceased was staying in a separate house near the school. That was the spot. So the body was found, so you can say that yes, the deceased was staying there. And to corroborate that, also the evidence of the son is there. Question is now that whether during the stay of the deceased at the spot, the accused had come to reside there or not. Yes. And more particularly, whether on the date of occurrence, on the previous night of the occurrence, was present or not. Yes. So that is totally silent from the evidence of PW1 at least. He was not able to see the person. She became PW1 the evidence of किसी जगह पर and the date of occurrence, that night when the occurrence alleged to have taken place, the deceased was in the company of the appellant. ତେଣୁ ସେଇଟା ହଉଛି ଭାଇଟାଲ ଥିଙ୍ଗ। ଲାଷ୍ଟ ସିନ୍ ଆପଣ କେମିତି ଆଣିବେ? ଲାଷ୍ଟ ସିନ୍ ଆଣିବେ ଯଦି ଆପଣ 15 ଦିନ ତଳେ ଥିଲା ତା ପାଖରେ ସେଦିନ ନଥିଲା ତାହେଲେ ରେଲେଭେଣ୍ଟ କଣ? ହଁ ସେଇ ଥିଲା ତାକୁ ଦେଖିଛନ୍ତି ଆମେ ଯିଏ ବେଷ୍ଟ ୱିଟନେସ୍ ଆପଣଙ୍କର 5 ସିଏ ମନା କରିଦେଲା ବାପା ଟୋଟାଲି ଆସିନି ଆମେ ବାପା ଆସିନି କହିଲା ଏଇ ଲୋକଟା କିଛି ଜଣାପଡୁନି ଯେ on the previous night he was there. That he had come once or twice, that's a different matter. She was continuing to stay at that place, and more particularly he was present on the date of occurrence in night. There is no evidence. That is not stated, right? That is that could have been influenced as last scene. Last scene evidence second place last if this evidence is not there, then who else has stated that on the night of occurrence, the accused was seen in the company of the deceased? CW3. Let us read it. Please place the evidence of PW. Post 37. Yes. And the accused person, he married BB. He married BB, who is a girl of my village. After marriage, BB was staying in the house of her in-laws
with her husband in village Buita. Bibi has died in our village. Since there was some quarreling between the husband and wife, Bibi came to our village. She came to our village 5 to 8 months prior to her death. She was staying in a government land in a separate house in our village. She was staying there along with her own children. 15 days prior to her death, accused came to her house. Accused stayed with the deceased in a separate house in our village. The deceased died on 4/5/2005, night on 5/5/2005. Her son Ravi Kuntia came to our village and informed about the death of our deceased. He disclosed that accused has dealt blow by a blunt side of a spade. As a result, she died. The spread was there.
This is hearsay because that P25 was not stated. Yes, right.
Hearing this, we proceeded to the spot. We saw her dead body. Her dead body was laying in front of her hut. We saw there was bleeding injury on the left side partial region near the ear root. We also saw her cloth was tied around her neck. Blood was coming out from her nostril and ear. On the same day, police came to the village. Police had inquest over the dead body and prepared the inquest report. Exit 2 is the inquest report and exit 2/2 is my signature on it. Police also seized blood-stained earth and sample earth in my presence and prepared the seizure list. Exhibit 3 is the seizure list and exhibit 3/2 is my signature on it. Police also seized the separate spread which was laying at the spot. Police prepared the seizure list and took my signature on it. Exhibit 4 is the said seizure list and exhibit 4/1 is my signature on it. I was examined by the cross-examination by the SDC. I have not gone inside the house of Bibi prior to her death. I don't remember the month and date when she came and stayed in our village. I have not gone to the house of accused in village Buita. I can't say the age of each one of the deceased who were staying with her in our village. Accused was staying with the deceased prior to the 15 days of her death. Accused was going to his work daily. I can't say when he was going to his work or returning. I have almost seen him standing in front of the village house of the deceased on each evening. I have seen him from a distance of 20 to 25 links. I have seen him at about 9 p.m. on the occurrence night. I don't remember if it was a dark fortnight. I have not stated that fact to anyone. I have stated this fact to police. I have got a bakery shop near this spot. I have seen him while I was coming from my shop after closing it. I had no talk with the accused on that night. It is not a fact that accused had not come to the house of the deceased during her separation. It is not a fact that I have not seen the accused on the occurrence of a night, nor his stay there 10 to 15 days prior to the occurrence. I have heard the death of the deceased from the son of the deceased, Ravindra Elias Puntia. When he disclosed this fact before me, Fiddle 2, Fiddle 1, Lambodar, and others were present there. The wooden handle of the spade would be 3 feet inch length. The width of the spade iron total was 7 inches. The sari was of the blue in color print sari. I reached the spot at about 5 or 5:30 a.m. It is not a fact that I have not started before the IO. That on the occurrence morning, Putia came and disclosed before us that the accused has killed the deceased. It is not a fact that accused has not assaulted the deceased nor killed her. It is not a fact that I am deposing falsehood at the instance of the informant since he is in my court ledger.
What is the question that has been put to the accused in the accused statement that he was last seen in the company of the deceased, particularly on the date of occurrence? Question number 4 is not that specific. It is stated that page 25, accused statement, it further transferred from their evidence that 15 days prior to the date of occurrence, you came and stayed in the house of so and so in a hut and so and so. We are concerned with a particular date, Mr. Tripathi. We are concerned what happened fourth night, 4-5 night. So this witness has stated that he had seen the accused standing there in on the night of occurrence at about 9 o'clock. Please come to again to that portion. I have seen him at about 9 p.m. on the occurrence night. उठिला घर सामने जेल देखिला ये क्वेश्चन का गोटे इंक्रिमेंटल सर्कमस्टांस हिसाब रे जदि आपण यूज करिवे accused को ताले क्वेश्चन पचारिबार थिला so that he give explanation आपण कोन पचारिचंती बा कौनसी क्वेश्चन 30टा क्वेश्चन भितरु एई क्वेश्चन का पचरा होइसी जे 4 तारीख 4-5 रातिरे he was company of the deceased, or he was seen in his house, or he was standing in front of the house. Except that question number 4, जो 15 दिन पूर्व से आसिक वही थिला. Now, if you come to the evidence of PW4, well, PW4 is as piece number 40. Right. Well, that line which he has stated in the last line, that is page 40, I have seen the accused in our village within 15 days, within that 15 days. Right. And I have seen the deceased on 4/5/2005 in our village. But in cross-examination paragraph 3 at page 41, right? 1, 2, 3, 4, 5. 5 lines from the top of that paragraph number C. That I have not seen accused on 4/5/2005. So which is the main thing? So that is not relevant. Relevant ଚାରିଟା ଘଟଣା ଦିନ ସନ୍ଧ୍ୟାବେଳେ ସେ ଦି ଜଣ ତାଙ୍କ କମ୍ପାନୀକୁ ଫିଲିପିନ୍ ଆଣିଲେ. That is relevant. Then बाकी PW5 तो वाला PW6 is suspected that the deceased had told regulating the dispute in the person. Like, solution kind of solution. Accused claim to be heart of case 47%. Accused claim to be heart of the deceased 10 to 15 days prior to the death of the deceased. I've seen the accused and his wife came to our house as they were traveling and the previous day at the occurrence. The son of the deceased was about to answer and disclose that the accused was killed. And in para 1 also she has stated that there was a quarreling between the accused and the deceased. As the accused are not doing anything, I have heard from BB that accused are trying to sell his land, the property. She blessed with 8 children, therefore she opposed the sale. In paragraph number 7, if you find the heart of the deceased was to the eastern side of the road. I have gone to the heart of the whose door is to the east, and I have not gone inside the house of so and so prior to the door. There is no outside the house so and so. ପୂର୍ବଦିନ ସକାଳ 9ଟା ବେଳେ ଆସିଥିଲି କିନ୍ତୁ ମୁଁ ଶୋଇକି ଦେଖି ବାପା ବେଳକୁ ବାପା ଘରେ ନାହାନ୍ତି ପୂର୍ବଦିନ ସକାଳ 9ଟା ବେଳେ ଆସିଥିଲି. started also in the କାରଣ ରାତିରେ ଘଟଣାଟା ହେଇଛି. So we did 164 statement. So before the magistrate that the Bapa ତା ପୂର୍ବଦିନ ସକାଳ 9ଟା ବେଳେ ଆସିଥିଲେ ସେ ଶୋଇଥିଲେ ଆପଣ ଆଡ୍ୟୁସ୍ କରୁଛନ୍ତି. So because in total case ମନେକର ଗୋଟେ husband and wife if they were present in an evening, okay, the dead body would have found of the deceased on the next morning with bleeding. It's a case of homicide and the accused absconds and is not offering any kind of explanation. Then it would be his special knowledge that if he was in the company of the deceased on the previous night at a place where the occurrence took place, matter is different. But here, the deceased was sleeping outside, outside the hut. So ଘର ବାହାରେ ଏଠି ଇଏ କରୁଥିଲା ଏବଂ ଆପଣଙ୍କର ଏଭିଡେନ୍ସ ଯଦି କିଛି ନାହିଁ ଯେ ତା କମ୍ପାନୀରେ ଥିଲା ଲାଷ୍ଟ ସିନ୍ ଆଉ ଏଇ ମୋଟିଭ ପାର୍ଟଟାକୁ ଆଣିବାକୁ ଚେଷ୍ଟା କରୁଛନ୍ତି ଆପଣ ତା ପାଇଁ ସେମିତି କିଛି ଏଭିଡେନ୍ସ ନାହିଁ ଡକ୍ୟୁମେଣ୍ଟାରୀ ଏଭିଡେନ୍ସ କାରଣ ସେ ଯାହା ବି ଆଣିଛନ୍ତି ସେ କହୁଛନ୍ତି ପ୍ରପର୍ଟି ଇଜ ଷ୍ଟାଣ୍ଡିଂ father and uncle. That means it was not the exclusive property which he could have disposed of without the consulting his father or the uncle. So, in that way, the motive part, which is one of the important aspect in a case of circumstantial evidence, that also cannot be said to have been established with clinching evidence. ବାକି ଘର ବାହାରଟାରେ ଗୋଟେ ସ୍ତ୍ରୀ ଲୋକଟା ପଡିଛି ମରିକି ଏବଂ ପାଖରେ ଇଲେକ୍ଟ୍ରନ ପ୍ରେଫରେନ୍ସ ପଡିଛି ଆଉ ତା ଛଡା କିଛି ନାହିଁ ଆଉ ପୁଅ କହି ବାପା କେବେ ଆସିଥିଲା ବୋଲି ସେ ତ ଟୋଟାଲ ମନା କରିଛି 164 ରେ ମଧ୍ୟ ଷ୍ଟେଟମେଣ୍ଟ ଅଛି ଯେ ସକାଳ 9ଟାରେ ଆସିଥିଲା ଆଉ ସେ 164 ତା ପୂର୍ବରୁ ଆସିଥିଲା ତ ତା ସେଥିରେ ବି ନାହିଁ so in circumstance we can say that the chain of circumstance is so complete that it only points towards the guilt of the accused or that nobody else who can commit the crime except the accused. Bahare padichi, so anybody can commit it. Particularly, how can PW3 has seen him mallet? And the PW3 is cross-examination failed mallet that he has seen him on the table night. I have seen him from a distance on 20 to 23. I have seen him at 9 p.m. on the occurrence night. Could be classified. On the occurrence night of Harrison, because the details of him in the front of the house of the deceased, he has seen him. No, we asking, we are people to you that if you want to utilize this as an incriminating circumstance, it is required on the part of the trial court to put questions in the accused statement or not. That is the question. If you do chance to explain how. Plus, you the qualified ତାପରେ ମୋ କାମ ଆସିଲା ମୁଁ ପଳେଇଲି ସେଟା କରିଥାନ୍ତା ନା explanation କରିଥାନ୍ତା. It is not there. That question was not. That was stated in the cross-examination, not in the examination. The incident blunder has been committed by the State Defense Counsel, whosoever it may be. He should not have put these questions in the cross-examination. There was nothing in the chief examination. He has brought it out in the cross-examination. How can evidence achieve? What is the cause of death as per the PM? Who conducted PM evaluation? PW Terminus. What according to him is the cause of death? Hemorrhagic shock due to injury. Assault on the head organ like brain. Assault on the head, brain. Now, another thing also we look at on another angle. But suppose the marriage is there for 19 years. they were blessed with so many children, and some kind of dissension arose, for which she came and stayed for some point of time with PW1, let us say accepted. Then she went to stay separately at Swanford. Unless the dissension subsided at the instance of somebody else. So whether they would be accepted that they stay together. ଆପଣଙ୍କ ଝଗଡ଼ା ହେଲା, ଝଗଡ଼ା ହେଇକି ମିଳାମିଶା ହବାର କିଛି ନାହିଁ, କିଏ ମିଳାମିଶା କଲା ନାହିଁ, so ଆସିକି ରହିବେ କେମିତି ଏକାଠି, ଆପଣ ସେ ଏଭିଡେନ୍ସ ତ ଆଣିନାହାନ୍ତି ନା?
But my 3, 4, 6 and 12 they have stated that prior to 15 days we have stayed.
Why he came? So she was assaulted. She was assaulted by the accused, for which she came back. She came to her brother's house. Brother said, yes, for this purpose he came, and then died separately. So if accused will be allowed to stay in the company of the deceased, he had constructed a house in the government dam, and she would allow the accused to stay with her only when the matter subsides between not or square. ମାଡ଼ ଖାଇକି ଆସିଛି, ବାପ ଘରକୁ ଆସିଛି, ବାପ ଘରେ ପରେ ଗୋଟେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଜାଗାରେ ଘର କରିକି ରହିଛି, ହେଲା, ତ ତାଙ୍କ ଭିତରେ ପୁଣି ମିଳାମିଶା ହେଲେ ବା କାହା ଜରିଆରେ ମିଳାମିଶା ହେଲେ ତ ସେ ଏଭିଡେନ୍ସ ଆପଣଙ୍କର କାହିଁ?
Because the PW6 has stated they were carrying previous by rupee person. ପାଖରେ ଅଛି ଝଗଡ଼ା ବି ହେଇଥିଲେ PW6.
PW6.
So let's state. Para to the last 3 members. I have seen the accused and his wife when they came to our house, there was quarreling between them on the previous day of occurrence. And in the para 1 also, she has stated, manner that there was a problem, there was quarreling between the accused and the deceased, as the accused was not doing any work. I have heard from that accused was trying to sell his landed property. And when she opted, there was quarreling between from the last day. That is there.
Despite perhaps he was not stated before police, but was confronted to this witness in paragraph number 8. ଯେ ତା ପୂର୍ବ ଦିନ ସେ ଆସିଥିଲେ ଝଗଡ଼ା କରି ତା ଘରକୁ, confrontation it is not a fact that I have not stated before the IO that the accused and the deceased went to our house in the evening on the previous day. Now, let's see that IO's evidence that I will explain. PW7,
I use the 10. Oh, sorry, 7. I use the 7.
ये witness कितना नंबर सकिएगा PW6.
6.
He will be sole investigating officer or there is anybody else. No, he has handed charge of investigation to somebody. That is not there. Page 67 Page 67 କରନ୍ତି ସେ ବେଳେ ବେଳେ ସେମାନଙ୍କର ଦେଇଦେବେ ସେ ବାପା ଝଗଡା କରିଦେବେ ଆମେ ଯାଇ ମାମୁଁ ଘର ପାଖରେ ରହିଥିଲୁ ପୂର୍ବ ପୃଷ୍ଠ এটা দেখিয়ে তার ভলিউম 2টা দিয়ে Before our 161 law, it cannot be limited for the utilizer. When substantive evidence makes what I was saying, whether it to state like presently the police structure area is the 164 area, so that is also incorrect. To suggest करते ସେଟା ବି ଏଥିରେ ନାହିଁ ପୁଲିସ ମନା କରୁଛି ମୁଁ ପୁଲିସ ପାଖରେ କହିନି suggest କରୁଛନ୍ତି also incorrect. As it is not been stated before the magistrate. I have not stated in my 164 statement that my father came on the morning on 4-5 and went away. You find the same statement. I have given the statement. It is a fact that I have stated with you that my father was absent in the house when I saw my mother die. Not a fact that I was stated with you that on the said night I woke up for passing urine when I saw the accused assaulted my mother by means of a spread fracture. Suggestion that irrefutable. Postal particular. It is not a fact that I have stated before you, but on the said night I woke up for passing urine when I saw accused assaulted my mother by means of I shouted at the and out of here I slept. Where say suggestion reason would have denied also. So that's a problem. Yes, anything else you want to say? No. All right. Take down. This year in the number 15 of 2008. The appellant Joga alias Jogavindu Malik faced trial in the court of planning ad hoc additional session judge FTC Balasore in ST case number 22/153 of 2007 for offense punishable under Section 302 of the Indian Penal Code and the accusation that in the right of the 5th of May 2005 at these Akhar Swan, he committed murder of his wife alias Padmavati Mahali, bracket hereafter be deceased. The London trial court died in judgment and order dated 35/2008 found the appellant guilty of the offense charged and sentenced him to undergo rigorous imprisonment for life. The prosecution case will sought as per the first information report lodged by PW1 Chandra Das, command, the brother deceased on 5/5/2005 before the Sadar Police Station, Balasore, in short is that the marriage between the deceased and the appellant was solemnized 19 years prior to the date of occurrence. And they were still in the village Sanpada to the children for 6 to 7 months constructing a house there. On 5/5/2005, at about 6 a.m., the informant gave some message about the deceased, came to Sanpada village, Sanpada, and found the deceased lying dead. And there were bleeding on the head of the deceased, which was caused by a speed, and the speed was lying near the dead body. It is further stated that the appellant was assaulting the deceased repeatedly, and on 4/5/2005 night, after killing the deceased, he had absconded. On the basis of such that scribe of the FIR is PW, or he has not been examined? He has not examined. He has not been examined. Okay. One Ananta Pradhan scribed the FIR as per the instruction of PW1, and after his presentation before the officer in charge of Baleshwar Sadar Police Station, on the PW9, what is the PW9 problem? Ananta Pradhan, PW9. Baleshwar Sadar Police case number 105 dated 5/5/2005 was registered under section 302 of the Indian Penal Code. The officer in charge of examining who registered the FIR. PW7 is the right. 7. The first was examined as PW1. अच्छा, that the officer in charge of Sadar Police Station in native bracket, that is PW7. Stop. PW7 himself took up investigation of the case. During the course of investigation, he deputed a constable to guard the dead body, examined the informant, sent requisition for the scientific team, visited the spot on 5/5/2005 and prepared spot map exhibit 6. Inquest over the dead body and prepared the inquest report exhibit 2. He seized the weapon of offense, that is spade, which was lying at the spot as per seizure list exhibit 4. He sent the dead body for postmortem examination. Seized the Boston arc and sample arc as per seizure list exhibit 3. Though the investigating officer searched for the appellant, but his whereabouts could not be ascertained. After the postmortem examination, the appearance of the deceased were produced by the constable before the IO bracket PW7, which were seized as per seizure list exhibit 7. PW7 sent requisition to the medical officer who conducted postmortem examination and sought for his opinion regarding the possibility of injuries sustained by the deceased with the seized spade, and received the opinion from the doctor. He also took steps for sending the exhibits for chemical examination to SFSL Rasulgarh through court, and received the report of the chemical examiner guide exhibit 20. On 7/9/2006, PW7 handed over the charge of investigation to the investigating officer who took over the charge.
Deputy Constable Mangal Singh. Sorry.
Who took over handed over the charge of investigation to PW8 Sudarshan Das. Who also visited the spot, examined the witnesses. On 14th 2006, the appellant was arrested and forwarded to PW5, the son of the appellant and the deceased, were produced before the court, and the statement under Section 164 CRPC was recorded, and on completion of investigation, charge sheet was submitted on 5/12/2006 against the appellant under Section 30 of the Indian Penal Code. Stop. After submission of charge sheet, complying with the procedure, the case was committed to the Court of Session, where the learned trial court framed charge against the appellant as aforesaid. Since the appellant pleaded not guilty and claimed to be tried, the Sessions trial procedure was resorted to establish the guilt of the appellant. In order to prove its case, the prosecution examined as many as 14 witnesses. I'll give the details. The prosecution also took 14 documents as exhibits and they were so and so, so and so. The defense plea is one of the denial. Next para, the learned trial court, after assessing legal as well as documentary evidence, came to hold that all the witnesses have stated that they came to know about the incident from PW5 and proceeded to the spot forthwith and found the appellant absent in his house. The learned trial court further held that from the inquest report and from the postmortem examination report, it is crystal clear that the death of the deceased was homicidal. One, due to injury on the vital part of brain, and the injuries were antemortem in nature. The learned trial court further held that the documentary evidence coupled with ocular evidence considered together unerringly point out guilty finger towards the appellant. It was further held that the conduct of the appellant subsequent to the occurrence appears to be suspicious, and to escape from the liability, he had left the house. And that the appellant has not explained the reason as to why he absconded from the house or why he left the house immediately after the occurrence. The learned trial court summed up that the conduct of the accused subsequent to the occurrence and the oral evidence taken together pointed out that it was nobody else but the appellant who had committed the offense. And accordingly, found that the prosecution has proved the case under Section 302 IPC against the appellant beyond all reasonable doubt. Mr. Dilip Roy, learning counsel appealing for the appellant, contended that there is no direct evidence in the case, and the case rests upon circumstantial evidence. The circumstances proved by the prosecution are not clinching. They form a complete chain so as to unerringly point towards the guilt of the appellant. The last sin theory is not established by way of clinching evidence and relevant questions are not put in the accused statement so far as last sin is concerned, and therefore the sin could not have been used against the appellant. The learned counsel further argued that since in a case of circumstantial evidence, motive assumes pertinent significance, and the prosecution has not any clinching motive on the part of the appellant to commit the crime, the appellant is entitled to get benefit of doubt, particularly when the star witness on behalf of the prosecution is known as 1 the son of the deceased and the appellant had made a specific statement that in the night of occurrence, the appellant was not present in the house and that the dead body of the deceased was lying on the outer veranda of the house. Learned counsel further argued that absconding itself cannot be ground to convict an accused for offense punishable under Section 302 of the Indian Penal Code. And therefore, the judgment and order of conviction is liable to be set aside. Mr. Rajesh Tripathi, then additional standing counsel, on the other hand, supported the judgment and argued that even though PW5 has not supported the prosecution case, but declared hostile by the prosecutor, but it will appear that in 164 CRPC statement, he has stated about the assault on the deceased by the appellant, and more particularly the presence of the appellant on the previous day, on the date of occurrence. The learned counsel further argued that the evidence has common record that on account of property since the appellant wanted to dispose of the landed property and it was opposed to by the deceased, there was dissension between the two, and she was assaulted, for which she left the house of the accused and came back to stay at her paternal place by constructing a house in the government land. The same can be said to be the motive behind the commission of offense. The land counsel further argued that a number of witnesses have stated about the presence of the appellant at the spot and that he was staying in the company of the deceased prior to the occurrence. And since the appellant was found absconding from the date of occurrence, after the occurrence, it can be said that the chain of circumstance is complete and the learning trial court has not committed any illegality in convicting the appellant under Section 302 of the Indian Penal Code. Adverting to the contention raised by the learning counsel for the parties, it is not disputed that there is no direct evidence in the case, and the case is based on circumstantial evidence. The principle for appreciation of a case based on circumstantial evidence is well settled in case of so and so. Keeping in view the principle laid down by the Honorable Supreme Court in Sarat Brichans Sarda, we are to assess the evidence on record to see whether the prosecution has established the circumstances with clinching evidence and whether the circumstances taken together form a complete chain and whether that complete chain points out towards the guilt of the accused, and it can be safely concluded that it is the accused appellant and appellant alone who has committed the crime. Before going to assess the evidence, ocular evidence, we think it proper to see whether how far the prosecution has established that the deceased met with a homicidal death. The investigating officer, bracket PW7, after he visited the spot on 5/5/2005, conducted inquest over the dead body and prepared the inquest report exhibit 2. He also sent the dead body for post-mortem examination, and the doctor statement and the doctor bracket PW10 conducted post-mortem examination at District Headquarters Hospital, Balashore on 5/5/2005, and he noticed so-and-so injuries, cord injuries, and he has specifically opined that all these are anti-mortem in nature. Time since death was within 36 hours of the examination, and cause of death on account of hemorrhagic shock due to injury to the vital organ like bone. He has further stated that the speed was produced before him, and after verifying the same, he gave his opinion that sustained by the deceased were possible by the said speed, and postmortem report has been marked as Exhibit 1. Nothing regarding the cross-examination discard the evidence of the doctor. The learning counsel for the appellant has also not challenged the finding of the learning trial court that it was a case of homicidal death. Considering the inquest report, the evidence of the doctor, bracket PW3, the postmortem report, there has to be only that the trial court has rightly come to the conclusion that the deceased made homicidal death. So far as the circumstances on which the prosecution relies in this case are: number one, there was previous hostility between the appellant and the deceased, as the deceased was raising objection for the appellant for making attempt to sell the landed properties. Number two, the last seen of the appellant in the company of the deceased. Roman 3, the abscond of the appellant after the date of after the murder was committed. As circumstance number one, that is the dispute between appellant and the deceased is concerned, which can be said to be motive crime as per the prosecution case. Stated, people one commanding the deceased has stated that 2005, deceased raised objection when the appellant tried to sell the landed properties. And the appellant assaulted the deceased, for which the deceased came to their views, and there was in that regard, and the deceased in a separate house school. The cross-examination, however, has stated that the appellant had joint property of 1.5 acres of land, and that he had not seen the document, and he could not see the location of the land. He further stated that the property stood the father of the appellant and the uncles, paternal uncles of the appellant, and that to his knowledge there was no landed properties in the appellant, and there was also no property in the home of the deceased. We stated that the appellant sold some land, but he could not say to whom the land was sold and to what extent. Of this witness in the cross-examination makes the statement in the chief examination that the appellant had tried to steal the landed properties. If the properties should be recorded in the father of the appellant, so also the uncles of the appellant, and there is no documentary evidence that the authority appellant to sell such land, it is not believed that the appellant would try his attempt to sell the land, and that the deceased would raise objection for this very dissension between them. The other witnesses who have stated about such dispute have stated in a good manner. Therefore, we are that there is preaching evidence on record that the appellant wanted to sell his landed properties and that the deceased was raised the objection for which there was dissension between the two. Case of circumstantial evidence motive assumes ultimate significance. Absence of motive puts the court in doubt to scrutinize the other evidence on record. In this case, when the prosecution has come forward with a particular motive behind the commission of the crime, and we find that the prosecution has been unsuccessful in proving the motive, to assess the other evidence on record to see how far those are established and whether the chain of circumstances is complete or not. The next circumstance is the last scene of the appellant in the company of the deceased. The star witness on behalf of the prosecution is none else than P.W.5, who is the son of the appellant as well as the deceased. He was aged about 2 years when he reached in court. Some final questions were put by the trial court, and he answered to these questions, and after verifying the answer, the court came to a finding that the witness was able to give a rational answer, and therefore he was declared to be a competent witness and his evidence was recorded. 5 stated that the deceased died in his Pakhar Swan, and there was quarrel between his father, bracket appellant, and his mother, bracket deceased. As a result of which, the deceased came to his Pakhar Swan and stayed there. He further stated that he himself, along with his 3 younger sisters, came with the deceased and stayed together. And the deceased died in the night, and in the morning he came to know about the death as he saw on the ear of the deceased, and she did not respond to his call. He further stated that he went to call his paternal uncle, that is the PWI, and he could not say how the deceased died, as he had slept in the night. In the cross-examination, stated that when they came to his Pakhashwa, they first stayed in the house of PW1. And as there was some discontent, command the deceased lived to the house of PW1 and lived separately. And the house was one-room house, and it was a one-room house. He further stated that on the occurrence night, the deceased was sleeping outside the house as it was summer season. And we were staying in that house for about 2 days after leaving the house of PW1. PW5 specifically stated that the appellant had never come to the house where they were staying, and that the appellant had never come to the house of his mother on June 5, 2005. Therefore, this evidence of the star witness on behalf of the prosecution is completely silent about the presence of the appellant in the house, in the spot house. This witness has been declared hostile, and his previous statement recorded under Section 164 CRPC has been confronted to him. But law is well settled that the statement of a witness recorded under Section 164 CRPC is not a substantive evidence, and it may be used for contradiction or corroboration of the witness who made it. Such a statement can be used to cross-examine the maker of it, and the result may be to show that the evidence of the witness is false. In view of the settled position of law and the fact that in 164 CRPC statement, the appellant of the 5 has not whispered about the presence of the appellant in the night in question with the deceased in the spot house. We are admitting that from the evidence of PW5, it is not established that the appellant was last seen in the company of the deceased. The other witnesses who have stated about the appellant staying with the deceased have stated it vividly. And PW3, though has stated that he had seen the appellant standing in front of the house of the deceased on each evening, and he had seen him from a distance of 20 to 25 minutes and had seen him at about 9 p.m. on the occurrence night. Number 3 number. But most particularly, the questions have been put in the accused statement regarding the passing of the appellant in the company of the deceased. The examination of the accused is for the purpose of enabling to explain any circumstances appearing in the evidence against him. Each separate piece of evidence in support of circumstances is to be put to the accused, and the accused may or may not avail the opportunity for offering his explanation. In the trial, the purpose of examining the accused under Section 313 CRPC is to meet requirement of principle of natural justice. The circumstances which are not put to the accused in his examination under Section 313 CRPC cannot be used against him and must be excluded from the consideration. The accused has a duty to furnish an explanation in his statement under Section 313 CRPC regarding any incriminating material that has been produced against him. If the accused has been given freedom, silent, then such entitled to draw inference, including an adverse inference against the accused as may be permissible in accordance with law. Some of the court judges have stated that people this prior to the date of occurrence, the accused was staying in the company of the appellant, but when the specific evidence relating the appellant in the company of the deceased in the night in question is absent, and since the evidence adduced by PW3 in that respect has not been put in the 313 statement, and more particularly in view of the evidence of the son of the appellant and the deceased, that the appellant had not come to the hot in question on the date of occurrence, and that he was never staying there till then, we are of the view that the prosecution has not succeeded in establishing this last scene theory against the appellant. So far as the absconding of the accused is concerned, it would have been relevant if there would have been clinching evidence regarding the presence of the appellant in the sport house or in the company of the deceased in the night in question. Since we have already held that there is no such clinching evidence that the appellant was in the company of the deceased on the night of occurrence, only because the accused was arrested at another place on some other day, it cannot be said that he was absconding. Law is well settled that absconding itself is not sufficient to draw an inference against the appellant that he is the author of the crime. Inasmuch as a person may abscond when he came to know that somebody is, the police is suspecting his involvement in the crime. In these following discussions, we are of the view that the circumstances have not been established with clinching evidence. The circumstances taken together do not form a complete chain. The motive behind the commission of the crime is absent. There is no clinching evidence relating to the larceny of the petitioner appellant in the company of the deceased. And in that view of the matter, the judgment and order of conviction of the appellant under section 302 of the Indian Penal Code is not sustainable in the eye of law, and accordingly the same is hereby set aside. Whether this man is on bail or he's in bail. Okay, it is stated that the appellant is on bail, the bail bond and the surety bond stands cancelled. With a note of appreciation, you have engaged as the amicus curiae, the legal ad board, with a note of appreciation on Mr. Roy and Mr. Tripathi. जैसे 313 ने just add कर देंगे. So in question number 4, 15 and 21. Question number 4, 15 and 21, it was put to the accused that from the evidence it appeared that for last 15 days he had been staying with the accused, but no specific question has been put that on the night of occurrence he was in the company of the deceased. So that's all for today. Here's evidence. Here's evidence how we deal with it in an elaborate manner. We deal with public. Yes. This is a matter earlier mentioned for us, but also students take up the matter for want of notice to informant. Plus, you are pleased to issue notice informant, six from the So, yes.
Criminal Appeal 96 of 2023 specifically directed this matter to be listed on 22nd December. What purpose it is for doing or what? The bail matters never been listed. Please. Bail matters never. Please give me. Don't mention. Please give me. I want to mention that race vigilance appeal admission commission 3 years. Investigation IA number 2987 arising out of CRL number 133 then IA filing dela ଗୋଟେ mail पे ଆଉ ଗୋଟେ ହଉଛି visualization stay on visualization of file ଆଉ ଗୋଟେ stay on judgment କିନ୍ତୁ judgment ଟା order pass ହେଇନି ସେତେବେଳେ ତା ଜାଗାରେ ଭୁଲରେ pass ହେଇଯାଇଛି visualization of pardon one bail application has been dismissed for default and another time matter co-acquisition are included. Lots of modification and type of error has come up. Lots of can be taken up tomorrow.
Modification more on yes,
Hearing
Yes, Lordship.
2011 CBI matter earlier listed. Listed ଥିଲା
All right, we'll see. Yes.
May I please, well.
That was a previous one.
Yesterday, case was posted for trial, but no witness was examined. Status report was called for, and my lord has dealt in 15/12/23 order. That after
14 charge sheet witness and 7 have been examined.
4 have been dealt.
So 7, 4, 11, the list is 3.
My lord.
And you mentioned that the case is now posted for examination of informant and investigating officer, right? So what happened?
Yesterday, no witness was present and no witness was examined.
And in custody since when?
I am in custody 2/3/22. Date of occurrence is of the year 31/7/2021. I was arrested subsequently.
So it's not that because coming to the conclusion stage, we have just completed 2 years. 3
My lord. A local man, understand?
Complete it all.
Local man.
Trial to be completed by April to be related.
And what's it in the local
number 2636 of 23. There is an application for the counsel for the petition submitted, but though the date was fixed to 3/24 for recording the subject informed by the investigating officer as per the status report submitted by the London trial court. But he has received instruction that on that day he witnessed on the when counsel for the submits that the petitioner is a local man and he is in judicial custody since 2/3/2022. And since the trial is lingering, the petitioner may be granted bail for some time. When counsel for the state opposed the prayer for bail, considering the submission made by the London counsel for the respective parties for not inclining to release the petitioner and bail, taking into account the period of detention of the petitioner in judicial custody, allows the learning trial court to make a to conclude the trial by April 2024. The petitioner is at liberty to declare for bail if the trial is not concluded within the said period. Communicate the order to the learning trial court. Now register judicial to evaluate next.
Right. Item number 12.
Yes, Mr. Bal. कौन है? Oh, that is it's allowed. Yes, next.
Item number 3.
Interim bill application.
Yes, interim application. Other expired on 16/12/23.
16.
12/23.
So that period.
Lord, if
I
you
don't really
only to
Barsigal Geo within my bylaw.
only any protection for civic, you have 10 days or 7 days in it.
Rubana.
Ruban.
I remember 313 of 2023 is an application for interim bail. Consider. From the ground. The father of the petition has expired and in order to perform the subsequent ceremony, the presence of the petitioner So what is your date of surrender as per the earlier order?
Your Lordship, the bail was granted on 14/11. Then the date of surrender will be next week.
We released on bail on must have taken certified copy. So that is the date of your actual release, because it is to be counted from the date of release. So what is the date when you were released from the custody?
He was released on 15th, the Lordship, as far as my instruction goes. But
So that means is completed.
On Monday.
Cannot be this Monday. It may be after. So, Mr. Naik, have you obtained instruction on it?
I have forwarded this copy to the department. I have not get any instruction.
So get it, because the date is still there. So
Yes.
we can take up this matter next week.
Your Lordship, if it may be listed in the supplementary list.
I 307 of 23 is an application for extension of into which was granted as per order dated 18/10/20
11. 2023. Yes, sir.
Tracking 11/2023, IAR 1815 of 2023. One Council, Mr. Parthasarathi Daslan, Central Government, Parthasarathi Naik Central Government Council for NCB submitted that he has received the copy of the interim application and sought for instruction, and the matter may be taken up next week. It's supplementary and your so
11th.
how take up this matter on 11th of January 2024. Yes.
Grateful.
Item number 6. 6, Mr. That subsequently that clarification was made in this decision. What is that reference? That is not been, I think, reported. You have given that 17/3/20. Was there? I have given the copy matter. 17. Yes. The last decision. In page 12, your lordship may kindly have a glass to page 12, your lordship. Your lordship page 12, my friend. Yeah, जोड़ा दिल्ली में, तादरे 12 your lordship, no, we should give it. So, page 12, let us see what is there.
Paragraph 76.
Okay, the constitutional bench decision has been quoted in is paragraph 10, right?
Yes, sir.
Okay, that is relevant to paragraph of that decision is 74.
Yes.
Then they said that it has been it is based on that new part.
Yes.
So that amended act. So the paragraph 12, okay.
Para 13, sir.
12, no. 13, yes, sir.
Section 7, as existed prior to 26 July 2018, was different from the present section. On the amended Section 7, which is applicable to the present case, specifically refers to any gratification. The substituted Section 7 does not use the word gratification, but uses a term undue advantage. When the allegation is of demand of gratification and exception thereby taken, it must be as a motive or reward for doing forbearing to do any official act. The fact that demand and acceptance of gratification were for motive or reward, as provided in Section 7, can be proved by invoking presumption on Section 20, provided the basic allegation of demand and acceptance are proved. In this case, we are so that.
So these
Para 14, they have summed up
para 14.
the allegation of demand of gratification and acceptance made by a public servant has to be established beyond a reasonable doubt. The decision of the Constitutional Bench does not dilute this elementary requirement of proof beyond a reasonable doubt. Constitutional Bench was dealing with the issue of modes by which demand can be proved. The Constitutional Bench has laid down that the proof need not be only by direct oral or documentary evidence, but it can be by way of other evidence, including circumstantial evidence. When reliance is placed on circumstantial evidence to prove the demand for gratification, prosecution must establish each and every circumstance from which prosecution wants the court to draw a conclusion of guilt. The facts so established must be consistent with only one hypothesis, that there was a demand made for gratification by the accused. Therefore, in this case, we will have to examine whether there is any direct evidence of demand. If you come to a conclusion that there is no direct evidence of demand, this court will have to
Mr. Mahmood, I'm just please the evidence of that because we should placed yesterday that when it appears that, and also from the practice statement, it appears that so far as this acceptance and recovery, that is not disputed. Yes or no, it will say at least I found that this acceptance and recovery part was not been disputed. It's that amount which you have received, it is for some other reason.
That is, as a matter of fact, not might be, that is the version of the complaint, right?
That is the version of the complaint, right?
Yes.
But the thing is that he has dissolved from his previous statement. Number two, corroborated by the evidence, and particularly even in cases like that, that in 313 statement, you have not stated that I have given some loan.
Not I have given loan to my neighbor. I have taken that right. That is, that's a fact, but that it has, he cannot hear.
As if it should have been verified by the learning council was present at the time of recording of accusation.
Problem that senior counsel, they do not have time to remain present at the
Sometimes accused statement, if it is
very important in this such cases.
Some questions which are not answered for that, death sentence have been confirmed. You must have remembered that Lakshmi case, I think, that was no explanation was given of that while was shown.
Okay. The lordships have considered the evidence on record In that case, was not the case. And then your lordship may turn to para 19. In the present case, there are no circumstances brought on record which will prove the demand for gratification. Therefore, ingredients of the offence under Section 7 of the PC Act were not established, and consequently, the offence under Section 31 will not be established. Sure, to paragraph. Last page, Miller, para 19. Case, last paragraph is paragraph number 19, yes. So, but again, I think he will, that this is at the stage of final hearing. Finally. Question is, the finding that demand is not proved, they have not gone into other aspects. They have acquitted. No, he is pointing out one decision. He says that what you can do for the final stage of hearing, stay of conviction, I feel detailed analysis is made. I'm not I'm not bringing you except to go into detailed analysis. My favorite words that there is no legal evidence, and what he has relied upon the learned trial. Your lordships kindly see judgment. Which paragraph? अरे भैया जो क्या हमने फॉलो की उस पर क्या बताया हमको बुक में नहीं पढ़ मार दो ठीक है how he is going to that evidence of that before which paragraph and it's a part of demand that part of it. That please come to paragraph number 2. So there I think it has been para 10 it's here. From the above facts of evidence, it is revealed that independent material witness 1 and 4 have supported prosecution case of demand made by the accused to the complainant, but the complainant himself, even he has supported the prosecution case to a majority person, but has stated a different story to favor the accused in respect of demand. The course of argument, this is your argument, your lordship may skip. Two paragraphs are mentioned. So that ଭିତରେ କୋଉଠି ଅଛି so how he appreciated it ସେଇଟା 11 paragraph ମୋର conclusion କି ପଳେଇ ଆସିଲେ ନା 11 paragraph discussion କରିଛନ୍ତି regarding legal aspect concerning demand acceptance and recovery of money to find out if prosecution has been able to substantiate the contention of Aramaic. Okay, that is right. This page 30 and last 5 lines. Yes. As regards as regards such contention, it is to mention that on going through everything body to as regards such a though the evidence of the complainant or other independent examined case, it is not at all revealed any allegation against the DO. The evidence of the that means he has considered the case of FIR case against the DO. The evidence of witnesses do not disclose about an instant demand made by the said DO, and furthermore about acceptance recovery money from him. He has not been made an accused in this case. As such, contention of defense counsel that DO has made demand has no relevancy and it will not affect the prosecution case against the accused. Rather, let it be seen if demand has been made by the accused or not. The FIR Mahataj Exhibit 15 clearly discloses that on being approached to the DAO, the complainant was told to meet the accused for recommendation of subsidy. Even if complainant had approached the accused since month of June, the accused was not preparing the bill. On 16/11/2009 in the morning, on request of the complainant, the accused stated if at least 4,000 is not given to him, he would not prepare the bill. Such fact has been reiterated by the complainant at the time of giving statement before the magistrate under section 164 CRPC. PW 1 and 4, the independent witnesses have also corroborated such fact regarding demand in their respective statements. PW 1 and 4 were present during preparation when the complainant narrated about the FIR allegation. The preparation report also discloses the narration of facts of allegation to the trap party members, including independent witnesses, wherein the complainant has stated about demand of 4,000 by the accused. So this is the reasoning, and all of these what he has relied upon, these are all inadmissible evidence. FIR 164, statement of CW, preparation, and preparation report. These are all inadmissible evidence. But the complainant PW6 evidence discloses that when he met the accused, he has disclosed regarding loan given by him to one of his neighbors, which was to be returned to him, and the complainant had assured to return the said amount after passing bill. In para 3 of his evidence, complainant told to give the money which he had given to him by the borrower, and such loan amount had been given to the accused by him.
And this last page 27, internal page 27, page 40, this last 4 lines, such facts of
such evidence of indicates complainant has invented a business story being handed over by the accused.
Such fact is more fortified as because the accused has not taken hasi whatever se lagega sethi. Okay, Mr. Das, let us say that this specific plea which he would have taken, but about this loan, etc., he has not taken. But he has the right of silent. He has not taken that plea, but he has witness. The witness is the and in the trial could use a finding that it's presented a baseless story. And how you have proved the aspect of which is one of the crux of the matter. You say that he has not taken, we prove that loan to yourself.
PW1 and PW4, another witness and other official witnesses about them, the trial court has discussed vividly, number circumstantial evidence. And they have supported, according to the decision of the Honorable Apex Court in Nirav Datta and also other decisions which I have cited, if other circumstances are available, then it will be available against the accused that he has demanded the money from the, because this accused petitioner has no enmity with the debtor. The debtor had undertaken one work. The subsidy, he used to get the subsidy. He first made the district agricultural officer. Thereafter, the district agricultural officer asked him to meet the petitioner with whom the file is there, and he used to pass the same. Thereafter, he met this present petitioner. What facts are there?
Trial court of PW6 evidence.
Then he made this petitioner for getting the subsidy amount. So this PW1 and PW4, you lordship may kindly have a glance to the evidence of PW4 over your witness.
Just move along. So far as is concerned, Is it not in the initial case that the demand was not made by this petitioner, this appellant, it was made by Mr. X, who is not an accused in the case, who has not charge sheeted, whether he is become a prosecution witness.
Once he has admitted that this petitioner demanded 4,000.
Please come to that. That is why I'm asking you to come to the 6 evidence.
You are asking the kind of reference to the evidence of PW 6, paragraph 1, paragraph 2. Middle. In this way, I visited accused 4 to 5 times. Your lordship got it. In this way, your lordship, in this way. I visited accused for 4 to 5 times for a month. Ultimately, I met the staff of the accused who told him to bribe the accused to get my field pass. When I met the accused, he asked me about the loan 4,000 given by one of his neighborhood to me, and at that time assured that the amount of neighborhood to be returned to him. I assured him that after passing of my bill, I would pay said amount. So it has no relevance about the amount and this bill pass. So I will be satisfied, your lordship. However, as the accused made such delay in passing the bill, I visited Vigilance Office Court. My submission before the lordship is that he has got the bill to be passed by this accused. The money has been given by the borrower of this petitioner for a dictum. So there is no nexus, there is no relevance of passing of the bill and refund of the bribe money. Bribe money by X. And also your lordship will be astonished that this petitioner, this default, does not know who had given him bribe money. Address, etc. This is reflected by the trial court matter. The person who gave him to return it to the petitioner, is it not its duty? Who was given? How could he know? He does not know. The borrower of the borrower from the petitioner. He does not know the name and address. So that the trial court has come to the conclusion that new story he has come, he was by that. You also will see the judgment. I have read yesterday.
Also, that is the 100%.
We are not able to borrow it at all. So new story has been created. And this, when we describe that at the time of preparation, the independent witnesses who were present at that time, and PW 1 and 4, who are categorically stated that they are hard able to describe that unless he pays 4,000, he will not be passed. These are the circumstantial evidence, my lord. Number 1. Number 2, according to your lordship's observations and also the Supreme Court's observations, all these facts will be taken into consideration at the time of final hearing. My lord, senior friend read paragraph 19 and 20 of this judgment. That is the merit of the appeal. That is not the consideration of stay of condition, my lord. The decisions which I have cited before your lordship, I have relied on those relate to stay of condition, my lord. Including with that, my lord, senior filed your lordship's decision regarding Sushant Kumar Sahu. And also a short note with the citations copy have been given to me, and all those cases are relating to the merit of the appeal, not at the stage of conviction. This item 3, item 4 decisions which my lord senior has relied on, all those relate to the merit of the appeal, not consideration of stay. So whatever submissions are to be made by my lord senior, only if your lordship this scrutinizes this evidence.
Submission which you made that value to statement made by the decoy before the police that unless he pays rupees 4,000, the bill will be passed. Right, this is your submission that we are talking.
This evidence which I read.
No, please follow.
Statement, consistent statement is not with me, my lord.
No,
I said that always that is the case, my lord.
In your case, that means the best witness to say like that is PW6.
Yes, sir. Exactly. This is correct.
PW6 is the best witness to say that he told me, that means the appellant told me that unless I will 4,000, I will be my past, right? He has not stated chief examination, correct or not?
Yes.
If you are declaring this time,
Yes.
if there is a statement has been previously, whether it is required to be confronted to him or not,
Yes. Paragraph
whether it has been
paragraph 6 में kindly
so that
paragraph 6. So Lordship may kindly go through paragraph 6.
yes, please so that.
It is the fact that the person had gone to the vigilance office to make report without the
Lordship, please come to that just to me.
yes. I have not verified my grievance to the SP vigilance or made any statement to the magistrate of section 164 that my neighbor had given rupees 4,000 to me to return 4,000 to the accused.
I'm asking you personal questions.
I'm coming well. Your Lordship will be satisfied. I cannot say the name and address of the said person borrowed rupees 4,000 from the accused. I have not disclosed at the time of preparation before the independent official witness of Jalawad that the accused has to get rupees 4,000 from the borrower through me. I have brought the entire money by borrowing from autos, which was seized after the detection. And I had get back such amount of differing document. This is the said document basis of which I get back my amount marked exhibit 16 where exhibit 17 is my signature. I had applied before the season quarter to get back my money under exhibit 18 where exhibit 18 is my signature.
This is all the things which he has stated in chief examination, and he has stated that you are not stated like that in the statement. I am asking you that where you confronted me that you have made a statement before police, before the investigating official, that he told that unless this amount is paid, he will be passed. What is that confrontation?
Paragraph 9 may I refer to my lord. When the vigilance police came, I identified the accused and at that time vigilance also gave their identity. Having heard the presence of vigilance police, the accused became perturbed. When the vigilance police challenged the accused, he admitted. Yeah,
Mr. Nas, please try to follow. That hostile witness evidence cannot be just thrown out, right? Whatever support he is with, he can take advantage of it. Whatever statement it is advantage to, you can take it. Let us say that this 4,000 story he has developed trial and he has not stated, it is a contradictory one. But again, I'm asking you that unless you brought on record about that particular demand aspect, that this was the demand, and he said that unless the demand is fulfilled, this work will not be done. If that is not brought on record, I cannot just now see that 161 statement and say that he has stated. It has to be confronted in accordance with 145 of the Evidence Act and put to the investigating officer so that we can say that yes, this was the statement for police, and now he is giving a contradictory version, so his evidence will not be acceptable even if that evidence gives also these are the statements. So that statement, particular line, which is important line, but we have not brought out.
You are also kind of a glance to paragraph 17 cross examination. One line.
Yes.
Will I read my
Yes.
I was aggrieved on the accused as he committed delay in taking measurement of my work. As the accused made delay in measurement, and I made delay in handing over rupees worth 4,000, never by my father when the accused demanded, thus being aggrieved, I made report before the vigilance.
this also relates to that neighbor. About this neighbor theory, we are taking that
not in the cross-examination they have brought it. They have brought it, but in cross-examination by the prosecution, my lord, prosecution,
we are closing it to anything you want to
yes, yes.
please give it. So, yes, Mr. Moon, anything else you want to submit? Right? Anything for any further submission? The sum up that assuming that his evidence in court is not W4, there is no evidence of demand. Except that overwhelming witness continue on Anisha Kinatan. On Anisha quality, that cannot be assumed that relates to demand. On Anisha may also be related to this what we stated. Yes. And again, you find that PW4 he has admitted in para 7 that para 7 earlier occasion you also had seen it, which witness PW4 Miller. Just a minute. PW4 para 7. Middle portion Miller. Yeah. During our stay, notice the complaints of moving around the office premises. On my entrance to the office room of the accused, I found some outsider present inside the office along with the complainant. After complainant indicated me that he has made over the printed notes to the accused, I relayed signal to the party members. So this again creates doubt as to whether they seen anything or heard anything. If he saw it and heard it, he would have immediately given signal. Why would you wait for the complainant to give you the indication? Okay. So there is absolutely no evidence of demand, and on that period, in the rest of the case, the Honorable Supreme Court acquitted him on that finding alone. And two other cases also, that you know those cases, only on the finding that there is no demand is not food. Okay. In that Sushant Kumar Sai, your residence held that in a case where there is no evidence. That paragraph, I'll just place the paragraph from Sushant, I have dismissed that petition, but there is some observation. You say that so yesterday was mentioned about that. Page 21 million. Yes. There is no doubt, the paragraph beginning, there is no doubt that in view of the settled position of law. Yes, yes. The appellant has to make out a rare and exceptional case for the grant of stay against conviction under section 389 CRPC. There must be special and compelling circumstances in justification for the grant of such stay against conviction. There should be irreversible consequences leading to injustice and irreparable damages in the event of non-grant of stay against conviction. Impugned judgment of conviction should be based on no evidence or against weight of evidence, which must be practically appear to without conducting a detailed analysis. This item will be this. There is no evidence. And irreparable damage under the his children are reading. He has lost his job. No, he has not lost his job as yet. But once he is on the stage, there will be job and then the career of academic of his children will be ruined, which is irreparable. Not quite. Yes, Mr. Yes. I will submit to nothing.
Bangladesh's Dr. Kumar would be research relied on, and theoretically it has been held by their
That objection and mention question.
yes. In Brazil, losing a job is not an exceptional circumstances. In that case, number one. Number two, they have not, this petitioner has not mentioned any exceptional circumstances except losing of job and may not a senior submitted before the lordship. So, no exceptional circumstances under which,
Is it a fact or not that till date he is in service?
he's in service, states have been taken, government, is it at the consideration of government? I shall
No,
concerned.
as in today,
Take instruction.
he's making a statement, you can take over that instruction over from, there is no problem. As in, is giving his note by tomorrow. If you want to give anything, you can give, and if he has lost his service also, that instruction you get to this evening, you can mention it, and one piece.
I'm right, given right.
Dismissed or not, just one line. Just one line.
Yes, my submission is the money has been recovered from his position.
That's all I don't.
These facts will you consider?
This submission which you, Mr. Just take instruction and either yes or no.
Yes. I'm submitting before.
So I'm reserving it and just supply it tomorrow. That too.
So rely on the lordships in CR in the use of our and senior.
Okay.
Hi.
Lucky one. This is IM number 1723 of 2023. Are Mr. S.K.MISHRA, senior advocate, and Mr. Sanjay Kumar Das, standing counsel for the Islam's department. Order is reserved. Mr. Moon submits that he will file a written note of submission by tomorrow. He has filed some decision citations today which are taken on paper, and further submits that he will file a note by tomorrow, giving copy to the learning standing council. That's critical chairman.
Copy which are given, I think it is available. I will file in another other cases now because
He just put this seal here. That is the problem.
seal of particular.
He can give it from page 2 onwards. Ultimately, the first page of this is already given.
See which court or set aside.
So the first page of that.
I will file in other cases.
Yes, it's all like that.
Probably.
Just put it out.
Item 8.
Is this matter next week? Yes.
Item 11.
Yes, Mr.
My lord, in this matter, my lord, the petitioner they are languishing very costly since 2021. The quantity of the gun is less than 20 kg.
These are what purpose this matter has come?
Still to come, the appeal has not yet been admitted.
No, not yet admitted. Yes, sir, not made. Why it has not been made? What is the reason?
No, certified copy has already given because the three connected petition appeal is there. I have given a certified copy of one.
Proof of revision from
That is 77777.
777 in the case for people that are after filing of the certified copy. Not received the copy also. Also not received.
779, sir. 779.
ठीक से कौन पूछ रहे हैं? पूछरे 5टा ना 6टा केस
तीनटा मेरे
ଆପଣ ଗୋଟେ ଦିନ ଆଟଲିଷ୍ଟ ଅଛି ସାର୍ଟିଫାଇଡ
779
ଅଛି
ମାଇନର ଏଥିରେ ସେମ୍ ପର୍ସନ୍ସ ମୁଁ ଆଜି କରିଥିଲି without my consent we file another but I have no addition of any other arguments.
Just a minute. We want to see that the certified judgment is available at least in one case.
So yes.
That's all. Because all these are to be hard together. So अच्छी देखिए पास को Okay, if it is available, Mr. Panda, in CRM number 779, then you have to file an interim application. Dispense with the filing of certified copy. It's available, so and so. So that you file, you can and ask the. Okay.
Sir, filing my lord can also directly give
interim application file currency order to hubba tapre SR hubba tapre let them solve a copy and equal 7 and 778 and 779 two the double filing japan two
same accused মানে কম করছেন
ଆପଣ file କରିଦେଲେ
my lord but who has
ଆପଣ କଣ file କରିଦେଲେ
No, sir, he has given, he told me that all the accused
if a prisoner's petition comes
not they have that the petition filed by my lord said they have already that
to କିଛି ନାହିଁ
now
मतलब kindly come to the 42 item 11 ର ପ୍ରଥମଟା ଯୋଉ accused second ଟା 742 same accused ତ ସିଏ କହୁଛି ଯୋଉ ଲବଣୀ ସେଠୀର ଦିଟା ଆପିଲ ଚନ୍ଦନ ଏଗୁଡାକ ସବୁ ଆଗରୁ ମିଷ୍ଟର ଦୀପକ କୁମାର ପଣ୍ଡା ଫାଇଲ କରିଥିଲେ ଇଏ ତାକୁ ପଛରେ ଫାଇଲ କରିଛନ୍ତି ଯେ ପଛରେ ଫାଇଲ କରିଛନ୍ତି ଆପଣଙ୍କ ଆସିବ ଆକ୍ୟୁଜ ଯଦି ଆସିବେ ଯେ ନାଇଁ ଆମେ ପ୍ରଥମଟାକୁ ଆମେ କଣ୍ଟିନ୍ୟୁ କରିବାକୁ ଚାହୁଁ ମ୍ୟାଟର ଡିଫରେଣ୍ଟ ସାର୍ ବଟ୍ ଏପର୍ଯ୍ୟନ୍ତ ସେମିତି କିଛି
tag ହେଇନି that is there ଅଫିସର ଅଛି ଏବେ tag ହେଇନି ସେ they already withdraw that first three petitions
କିଛି ହେଇନି କିଛି ମାନେ ସେମିତି ସେମାନେ ଲେଖିଥିଲେ ସଫିସିଏଣ୍ଟ ଆପଣ ଆୟୁଷ ନହେଲେ ମତେ ଇନଷ୍ଟ୍ରକ୍ସନ ନବାକୁ
I am sure
କାରଣ ତାଙ୍କୁ କହିବାକୁ ପଡିବ ଦୁଇଟା ତମେ ଫାଇଲ କରୁଛ କୋଉଟା କଣ୍ଟିନ୍ୟୁ
sir when it has come to my notice that is them they have given assurance already with the first three petitions
alright ଗୋଟେ କରି ଲେଖନ୍ତୁ CRLN number 777 of 2023 copy देना which indicate that certified copy of the judgment has not been filed for which SR has not been made. Mr. Panda submits that The certified copy of the improved judgment is available in CRLA number 779 of 2023, and he will file an interim application for dispensing filing of the certified copy. He further submits that though the appellant earlier filed a criminal appeal challenging the self-same improved judgment and order of conviction in CRLA number 742 of 2023, but he has sent a petition for withdrawal of the earlier criminal appeal. The registry shall verify whether any such petition has been received from the appellant for withdrawal of CRLA number 742 of 2023 or not. ହେଲା ଏଇ ଟାଇପର ଅର୍ଡର ଆପଣ ଆର ଦିଟାରେ ମଧ୍ୟ କରିଦେବେ also to solve copy and total judgment of appeal अच्छा no appeal में देना let a copy of the appeal along with the improved judgment is served on the learning council for the state है ना ତାପରଟା ଦେଖିବେ ଆପଣ ଏଇ ଯୋଉ ବିଲ୍ ପ୍ରଭୁଙ୍କ ସେମିତି ସେ ଦିଟା ଅଛି ଆଉ ସେ ଇଏଟାର ସେଇଟା ଉପରେ ଅର୍ଡର କରିଦେବେ ଆପଣ ହେଲା ରହିବ ସେଟା ଆସିବ ଆଚ୍ଛା ବୁଝିପାରିଲେ କଣ ନାଇଁ ୟେସ୍ मैं
Item 14.
Yes, Mr. Mishra.
This is do conflict with on purpose. For the consumer
Condition.
condition.
Objection has been filed.
Huh?
Objection has been filed. You have received. Huh?
Objection has been filed. Copy has been served upon.
What is the offense here?
Offense penal section 7 of the PCI.
No other offense.
No other offense.
What is the prosecution case?
Prosecution case is that the PW1 with the complainant here. A FIR has been lodged against him under 498, 323 and 307 summers. The allegation that to delete the 307, I demand the bribe of rupees 20,000.
He is an investigating officer.
Investigating officer. Demand
That decoy, the complainant who was accused of the duty case. Offenses under that case were registered?
294, 307, 498, 341, 506, and 34 of Indian Penal.
You are the police officer of which police station?
Nihal Prasad Police Station.
You are the IAC or IO?
IAC.
IAC. Yes, then this
They are released on 41A, but all the accused persons.
now if then the report was made and what happened thereafter? Preparation was made or
Action was made
the amount right is 20,000.
from one Kalia. My इच्छा हो जाता होगा. Allegation was 20,000, but subsequently it was bargained and it comes around to 6,000.
It was not recovered from your position.
No.
So the prosecution case is that he asked it to be given to the another person.
Yes.
What is the name of that person?
Kalia.
He is a co-accused in this case.
Is a co-accused.
Kalia. What happened to him? The trial court.
Yes, sir. He was convicted.
Convicted.
He was convicted in one judgment under section 7 and 12 of the PCI.
Kalia, अच्छा भलो नाम है प्रकाश मालिक.
Prakash Mahalik. And another one, Lakshmana Sethi also convicted. Because he is one of the, as per the prosecution, he is one of the abator. I asked Lakshmana.
Prakash. Kalia.
Yes, that is the allegation. Complainant has to pay the amount Lakshmana and Lakshmana to Kalia.
Okay, complainant but decoy has been exact as
PW1 was declared hostile.
Then how the charges has been established against you?
And
The decoy terms hostile.
independent witness, they have declared as magistral witness. He is also declared hostile.
No, he might have stated about the handing over the money to that person, the co-accused.
Yes.
But what about you?
So far, I am concerned.
Yes. In the evidence of PWP,
PW2,
what is there against you?
he said that I have not seen anything.
So PWP also declared. I'm asking you what is the material?
Material is that when the complainant, the PW1, so far the PW3 and 4 is concerned. When PW1 asked Lakshmana, the prosecution said that Lakshmana, who was a history sitter, is my personal attendant. And
Mr. Mishra, I'm just asking in court, who has stated that he demanded money and asked it to be paid to Mr. X, who is co-accused.
three over hearing witness.
ଦେଖିବା କି ଦଉଛି ଆମେ ଯାଉଛନ୍ତି। He's come to the PW3 medicine. PW3.
So far the chief is concerned, Your Lordship, I tell you. In paragraph 2. On that day, as per the direction of the BDO Dhenkanal, I had been to the office of DSP Vigilance Unit, Dhenkanal, at about 8 a.m.
This is the mic properly. I'm not able to hear you. Yes.
Sorry, ma'am. Sorry, sir.
Yes.
That day, as per the direction of BDO Dhenkanal, I had been to the office of DSP Vigilance Unit, Dhenkanal, at about 8 a.m. PW2 was present there. By that time, Cutter Vigilance staff, we met Inspector Naik Babu. Then we started for a Nihal Prasad case for vigilance making. And we at Dhanni Chak, we made complainant on interception. He was identified to us by the Inspector of Vigilance. Their interception disclosed before us that the accused Chittaranjan Mehra, the then IIC Nihal Prasad demanded 6,000 to him as bribe amount to remove one section of the IPC from his case. When intercepting get 12 numbers 500 rupees GC notes in our presence to Aniruddha Naik, Inspector Vigilance. Vigilance constable shows a demo here to us. He put his hand in a chemical solution. The color feels it will be yes,
Complainant who was examined as, or because he was examined as PW1, and himself he was declared hostile. He made a statement before this PW3 that this appellant had demanded money. Right. So, on the spot, you were there.
on the spot, I was not there.
Okay.
So, for the accused statement is concerned also.
Right. No, we passed to that accused from whose position it was recovered. At that point of time, you were not there.
I was not there, but prosecution case is that I was in the hall where the recovered the transaction was made.
Okay. No, at that point of time, when that man received the money, nobody stated that at that
He says, this period, he says, I have given the hints.
well,
Yes.
you saw that line.
Then we proceed to the next paragraph. Then we proceed to 9% case and released at 10 a.m. The IOC was absent on that day. So we returned to the vigilance office, the internal inspector of vigilance kept the money, taking it from the complainant inside his office almirah. Then the inspector of vigilance prepared a report and took our signature. He directed us to attend the office on the next day. Accordingly, we arrived in his office at about 8 a.m. on 26 to 21. Cutter vigilance staff, the complainant, Subrajana, myself were there. We were there. Inspector of vigilance handed over the tempted money kept in his almirah on previous day to the complainant and directed him to hand over the same to the accused on demand. Directed me to accompany him again. Then we proceed to Nihal Prasad case of vigilance vehicle. The vehicle was parked 200 meters away from the PS. I, along with the complainant, went to the PS by walking. I was standing there near the entrance hall. Complainant, along with the accused Lakshman, had gone inside the said hall.
Just to pause for a moment. Accused Chittaranjan is this appellant, and driver car is the two accused. They are inside that hall.
Accused Lakshman indicated accused Chittaranjan that complainant came with 6,000 rupees. And accused Chittaranjan told Lakshman to instruct complainant to hand over the money to his driver Kalia. Accordingly, complainant handed over the tempted money to accused Kalia, keeping the photo paper with him. Accused Kalia took it and kept it inside the pocket by using his hand. Then I gave signal by putting my hand over to head to a vigilance party member who came to the spot, and I, along with the complainant, disclosed the entire incidents before them. Then Inspector of Vigilance recovered the printed money.
So that means at the spot also, we pass instruction to hand over the money to Kalia. So how far you have succeeded in this version in this explanation?
Yes. 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 4 paragraph 3. Paragraph 3. I have not received any written order from the and the one business consumer prepared the preparation report so also. I will be personally verified the tendered money kept in the almirah by the inspector. He proceeded to Nehru police station at about 8 on 26/2/2021 and arrived there on 10 to 10:30 a.m. I stood near the door of the place. The tracking numbers were there at a distance of 200 meters away from me, and I gave signal to them from that distance. We left the PS at about 2 p.m. also, and all the seizure list it was prepared. Well, it was prepared in the Odia language. Then it is a fact. I have stated the IO, I was standing inside the PS campus and watching the incident. I don't remember that if I have stated before the magistrate that on 26/2/2021, I was standing in the front door of the PS and Ointa City and Lakon City went to the PS or not. And it is not a fact that there is no such occurrence of laying trap or seizure of the anything from the possession of the accused persons or preparation of report and that I am deposing falsehood.
What plea you have taken in the accused statement?
In the accused statement, you will actually can see the accused statement.
The accused statement.
All 3 persons.
Chitramund S.K.SAHOO. Regular. এটা 8 নম্বর কোন আনসার দিয়েছি রেকর্ড লেখাই ଆଉ କି ଜାଣିନି ତାପରେ ସବୁ ମିଛ କଥା
ମୁଁ ଏ କେସରେ ଇନଭେଷ୍ଟିଗେସନ କରୁଥିଲି ଏଲିୟର କେସ୍ and it is also 13 ମିଛ କଥା 14 ମିଛ କଥା 15 16 transfer ମିଛ କଥା 18 also that questions evidence of PW4. So for PW3 is concerned, only one question that at question number 10, question number 10 and 11.
প্রশ্ন পছরায়নি
Question number 10 and question number 11. It further that at Dhanan and Chaka complainant and City disclosed before them that you have demanded 6,000 from him as bribe to remove one section of IPC from his case.
No, question transfer
You and your driver Kalia were inside the hall of the police station. In that time, Lakshmana, another accused, intimated with that complainant came with 6,000. And he told Lakshmana to instruct the complainant to hand over money to your driver, Kalia, and accordingly, complainant hand over the tendered money to the accused buyer. What do you say? Whichever. And you will also can see the statement of that other 2 accused, Prakash Mahanik and Lakshman.
कौन सा
Question number 12. The so far the PW4 is concerned. This is the IO and TLA. Okay. But here PW3 and sorry, another account Lakshman Sethi also. Question number 6.
No, so if let us say That two vital witnesses of the prosecution being examined as PW1 and PW2 have not supported the prosecution case.
Yes, yes.
But from the evidence of PW3, it appears that you are present at the spot, and when the complainant accused you, you asked him to handle money 6,000. You accused Kalia. And accordingly, that was done. So, if RTO instance, the other co-accused has received it, then you are equally liable.
Well, my humble submission is that first, whether the Lakshmana is an attendant or Lakshmana is a history sitter, the document has been exhibited by the defense also. The present appellant was examined as DW1. He was exhibited the documents there. He was in warrant in 7 cases.
Lakshmana complainant
Is one of the accused. Lakshmana is also one of the accused. He is the brother of the complainant.
Yes.
And he was a history sitter for which I issued the warrant of arrest and was arrested by me and forwarded to the court. That was in the CD, so also the entire record has been exhibited. So far Kalia is concerned, the prosecution was trying to describe that whether he is my driver, because he is not a driver at all. No deal has been seized, he has been seized, no insurance paper has been seized, but he has been disclosed as a driver of mine. And so far Lakshmana is concerned, the prosecution stated that to the 4 was the IO, that he was my personal attendant. In this respect also, I made an application to call for the CCTV because the entire police station was under the CCTV coverage. That was not been seized. And but the learned High Court says that it is burden lies upon the accused to prove and to prevail the entire CCTV.
ଆପଣଙ୍କର ସେ ତ କହିଛନ୍ତି accused ଯେତେବେଳେ ଅର୍ଥାତ୍ ଆପଣ ଯେତେବେଳେ ଆପ୍ରୋଚ୍ କଲା ଆପଣ କହିଲେ ଟଙ୍କାଟାକୁ ଡ୍ରାଇଭରକୁ ଦେଇଦିଅ ରାଇଟ୍ ତ ଆପଣଙ୍କର ଯଦି ଅଛି ଯେ କାଳିଆ ସାଙ୍ଗରେ ମୋର କିଛି ସମ୍ପର୍କ ନାହିଁ you have suggested this weakness like that.
It was not suggested to PW3.
So
it was not. But in this PW4 is concerned, it was suggested. PW4 was the trap-laying officer. In trap-laying officer, it was suggested, and it was also answered that there is no inquiry at all in respect of Kalia. And in respect of Lakshman Sethi also. Well, Lakshmi, can we see the statement of PW4?
Mr. Mishra, in a trap case, it is not necessary that he should himself receive it and from his position it will be recovered and can only be.
Yes.
So if you asks that you hand over to somebody else, and in that way he has admitted the commission of crime, so he can also be prosecuted, and accordingly the same thing has been done. So unless you dislodge the evidence of this particular witness, that is the witness and he seen the transaction, entire transaction. So and recovery of the money from the position of the co-accused Kalia, that is there. So the Kalia has taken a plea of complete denial.
And in certain it was billed in the office of the vigilance. The entire episode was made in the office of the vigilance.
That plea was taken, but no specific plea that it was recovered from my position, but it was this type of money and well. So,
and second, issue before my lord that, so for the PW4 is concerned, and the defense witness also.
Defense witness on it was the first date, that is 25/2/21. The trap was made. On 26/2/2021, trap was made.
ଆଉ ସବୁ ୱିଟନେସ୍ ଶୁଣନ୍ତୁ, ଆଉ ସବୁ ୱିଟନେସ୍ ଆସି ପରେ ପହଞ୍ଚିଛନ୍ତି। ସେମାନେ କେବଳ କହିଥିବେ ରିକଭରି ପାର୍ଟ ଫ୍ରମ୍ ଦି ସେ ଯୋଉ କାଳିଆଠୁ, କିନ୍ତୁ ଭାଇଟାଲ ୱିଟନେସ୍ ଆପଣଙ୍କ ପାଇଁ ହଉଛି PW3, ଯିଏକି ଦେଖିଛି ଯେ ଆପଣ କହିଲେ ଯେ ଟଙ୍କାଟା ତାକୁ ଦେ। ତେଣୁ other witnesses are also must have stated in vicinity or not. ଅନ୍ୟମାନେ ଯୋଉମାନେ
Said that I was present at there.
ଆଉ କେହି କହିନାହାନ୍ତି?
No.
Are you sure?
Yes, sir. Your Lordship, I see the PW4 and there is no evidence to that who was there.
Mr. Das, PW3 ଛଡା ଆଉ କେହି କହିନାହାନ୍ତି appellant present ଥିଲା ବୋଲି?
Your Lordship, can have a glance to the evidence of PW2. Independent witnesses acted as magisterial witness. Paragraph 3.
Paragraph 3.
Yes.
So ଏଇଟା ବି ହଉଛି ପ୍ରିପାରେସନ ଦଳ। ଘଟଣା ପ୍ରିପାରେସନ।
Paragraph 5.64.
So I just want to know that whether it is solitary evidence of PW3 stated about your presence at the scene of occurrence where money was offered and this appellant claimed that he handed it to Kalia, or anybody else has stated that the petition was also present there.
Out of total 5 witnesses have been present. PW1 is the dead. PW2 is the acted as the magistrate.
Right.
PW3 is the overhearing witness. PW4 is the TLO. PW5 is the I. So out of these witnesses, to some extent, this PW2 has been asked the questions regarding 154, but he has supported the prosecution case. Entire prosecution case along with his signatures. The documents along with his signatures, everything else he has admitted and marked as exhibits, except I do not know about any indication given in the party. It is not a fact I have stated before private career as per the direction. A 150 to confrontation. Say parata keval poduchi. Accused Zitarana took the tented money, kept it inside his pocket, and then Lakshmana Sethi, being the mediator, told the complainant to hand over the pursuant to the confront the rights. My submission before your Lordship that since I had to do their case, this present petitioner has lost his job. He has been dismissed from service. Number 1. Number 2.
That is mentioned in the objection.
Yes, it has been. It was given a memo of excellent.
Okay.
My non-friend has not mentioned anything else as to if your Lordship is pleased to grant stay, whether it will be restated in the summons or not, nothing has been mentioned in the stay petition. Number 3, my non-friend has filed an application for early hearing. Yet to appear in the call list. So, at this stage, after dismissal from the service,
no, early hearing can have 2023 arrived early.
Let them prepare the paperwork. It is not the stage when you have been dismissed from service.
He is not placing that interim application now. He is just placing that stay of conviction.
Stay of conviction. He goes on merit. And
ଚାହୁଁଛି ସେ ସାକ୍ଷୀଟା କହିଛି 3 ନମ୍ବର ସାକ୍ଷୀ ଯେ ଘଟଣା ତାକୁ କହିଲା କାଳିଆକୁ ହ୍ୟାଣ୍ଡ ଓଭର କରିବା ପାଇଁ ଟଙ୍କା ଏବଂ କାଳିଆକୁ ହ୍ୟାଣ୍ଡ ଓଭର କରାଗଲା। ୟା ପ୍ରେଜେନ୍ସ ଆଉ କିଏ କହିଛନ୍ତି କି ସ୍ପଟରେ ଆପଣ ଯୋଉ 5ଟା ସାକ୍ଷୀ କରିଛନ୍ତି ପଛରେ ପହଞ୍ଚିଲା ସିଏ ଶୁଣିଲା ପରେ ସିଏ କହିଲେ ପ୍ରେଜେନ୍ସ ଥିଲା ବୋଲି ପିଟିସନର ମିଶ୍ର ମାନେ କିଛି କହିନି
ପହଞ୍ଚିଲା ବୋଲି ସାଙ୍ଗେ ସାଙ୍ଗେ କହିଛି
ମନା କରୁଛି ସେଥିପାଇଁ ପଚାରି
Page 4 of the PW4. Police found the IAC was not present on the police station on a temporary room in which IAC was used to stay inside the premises of campus. Complainant of the accused Chittaranjan is mobile phone so and so. Even for page 4 of the last
line.
last 4.
When
Complainant talked with the accused with his mobile number so and so, and the IAC inquired is whether he had got the money. Money is 6,000. When the complainant confirmed, accused Chittaranjan directly
complainant talked with accused so and so over his mobile, and the IAC inquired from him whether he had brought the bribe money of so and so. When the complainant confirmed, accused Chittaranjan directed to pay the bribe money to accused Lakshman Sethi, who was his personal attendant. The complainant intimated about this conversation. The vigilance team denied. So that all the members returned to. As for now, is a first day incident.
second day.
Paragraph 4 टा second. ସେଇଦିନ ଟଙ୍କା ପାସ୍ କଲା ସେଟା ଲକ୍ଷ୍ମଣ
ତାର page 6 ରେ ଆରମ୍ଭ ହେଇଛି.
page 6 କୁ ଆସନ୍ତୁ.
Then all the members of the tripartite proceeded to middle and 7th line. Page 6, 7th line.
The accompanying witness remained inside the PS premises in front of so-and-so. Complainant Lakshmana Sethi went inside the hall of the police station where accused Chittaranjan was sitting on the office chair. And I want to tell you,
that is the that accused Chittaranjan was present there.
You are Chittaranjan, right?
Yes. Complainant made accused in front of the police station. Complainant made the accused Lakshman in front of the police station. Accused Lakshman took the complainant to the IAC in health process. Premises in front of the police station. The complainant and Lakshman Sethi went inside the hall of the police station where accused person was sitting in the office chair doing some official work. The complainant stood in front of the hall and visible to IAC. Accused Lakshman Sethi asked the complainant to remain in the door of the hall, went to the IAC and informed about the arrival of the complainant, which demanded money of 6,000. The IAC chairman told accused Lakshman Sethi to direct the complainant to hand over the bag to his personal driver Prakash Mahalik alias Kalia. Complainant against the accompanied also had the version of IAC. As per the direction IAC and accused Lakshman Sethi, the complainant handed over the bribe to 6,000 to accused Kalia.
Some information
and accused Lakshman Sethi also challenged for liaison assist the IAC demanding and accepting the bribe money 6,000 from the complainant and denied the charge. That is page 8. And so far you will estimate IAC the cross examination. I had not visited paragraph 8. I had not visited Nyaya Prasad police station on 26 May 2021 or 25 May 2021, the date of occurrence. Sorry, next day. But prior to the date of occurrence, to investigate about the affair in Nyaya Prasad PSC also. I had not visited Nyaya Prasad police station on 26 or on 25 to ascertain the genuineness of the fact in the affair of this case. I had gone to Nyaya Prasad on 26 2021 at 9:40 a.m. in connection with the affair of this case. Next, paragraph 8. But this, it is a fact, the purpose of demonstration for the trap was taken in Thane.
running right chapter and the complainant efficient argue matter of legal just you have to confine to only the state of condition. Yes, we are arguing as if we have to do that. In 16 paragraph 14 also, we against that accused, which is history sitter Lakshman Sethi. Right, I'm reading the order IN number 698 of 23. There is an application for stay of condition had Mr. Tushar Kumar Mishra, one counsel appearing for the appellant, and Mr. Sanjay Kumar Das, one standing counsel for the Vigilance Department. Order is reserved. Yes, next.
Item 15.
Last one, filing an approval incident, no last one, directed to trade instruction matter.
On what now?
Daughter's marriage.
Daughter's marriage of appellant. That is there and improved as per the report, my lords, with the civilian. Address verification easy. Address verification, it was there fresh matter for the first time only. This report was coming. Report my nation. So, correct things here. So and so in connection with so and so. But address they refer to that address only. Obviously, see, बाकी local security. Security. The time में अपना ये पहले वैसे marriage invitation card कौन?
I'm Miss Madam.
2914. केवल बाहर का इशू
18 तारीख
18 तारीख डिजाइन वाला 19 तारीख से लोकल सिक्योरिटी से दिन जान से वेरीफाई करियो देखिए लोकालिटी यदि ठीक थिबो ताले तम छाड़िबो लक्ष्य देखो आई नंबर 291423 is an application for interim bail on the ground that the marriage daughter petition was fixed to 19th January 2024. And the presence of the petition is necessary for such auspicious ceremony. The counsel for the state was asked to obtain instruction on this interim application. Today, the land counsel for the state has produced a written instruction received from Deputy Commissioner of Excise, SD, Barangpur, dated 16th December 2023, from which it appears that the SHO Salanpur Police Station, District so-and-so, Uttar Pradesh, has reported that the marriage of the daughter of the petitioner is to be held on 18/1/2023. The written report is taken on record. Considering the evidence taken in the interim application and the report published by the Land Council for the state, I am inclined to release the petitioner on interim bail for a period of 2 weeks from the date of release, subject to condition that local securities shall take the petitioner on bail. The rest of the terms and conditions shall be fixed by the land trial court. Yes. Well, that is 18/1/2024. The report by mistake they have stated 2023. So original report I have lots. There it is mentioned 18/1/2024. Your lodge. I said it is actually done. No, one of So in that report it is written 23, but in the original report that was sent, Xerox collection brand. Lots. And Xerox collection is already a place. Okay. The original report, your lordship, which was sent from Uttar Pradesh. No, if it is 24, then how can you submit a report dated 23 that it has been verified? That please see this. Yes, there it has been written 18/2023. But that please see it and answer it. এই রিপোর্টটা ମୁଁ ଡାକିଲି ଯାହା ଲେଖା ହେଇଛି ଡାକିଲି ଡେଟେଡ୍ ସେଇଆ କଣ କହୁଛନ୍ତି ଆପଣ? Original 24 ଅଛି ଜାନୁଆରୀ 24 ଆପଣଙ୍କୁ ପ୍ରଥମ ଥର ପାଇଁ 4/12/2023ରେ କୁହାହେଲା ଇନଷ୍ଟ୍ରକ୍ସନ ନେବା ପାଇଁ ରାଇଟ୍ ତ ଯାହା ଇନଷ୍ଟ୍ରକ୍ସନ ଆସିଥିବେ 4/12/2023 ପରେ ସେ ଭେରିଫାଇ କରିଥିବ ଆଣିଥିବ
They are verified. Report came, but in the report it has reflected that 18/1/2023 the marriage and fixed. Actually, marriage and fixed to 18/1/2024.
ओहो 24 से ताजर भूल that is a mistake. अच्छा
The original report which came from that.
अच्छा शिवरा खाली करेक्शन कर दियंतु ଆପଣ ये ताकू ये कर दियंतु जो शॉर्ट सिग्नेचर मारी हां से आरडा पाइलन सेटा भी दियन तार कॉपीटा हां से जो आरडा जोटा ओरिजिनल टा पाइसन दे दो यस नेक्स्ट केस
Item 16.
अच्छा ये फिश अप कर देंगे he has to file the surrender certificate. In this case, please
18.
The appeal is received from jail is not maintainable before this court. As arises against the sentence of 7 years past, it has to go to the session judge. Kuchinda session judge buझितो assistant session judge Kuchinda pass କରିଛନ୍ତି come to the judgment part. Let us see. Seven is 5,000, 5 is 3,000 concurrent ratio. So that's 7 years alone. 7 years alone, it is electronic. And the JCILA has been filed by the appellant Soros Kantila challenging judgment and all dated past August 2022. Passed in ST case number 53/6 of 2122 in convicting the appellant under section 307 and 326 of the Indian Penal Code and sentencing him to undergo RI for so and so and so on. The stamp report has pointed out that the appeal is not maintainable before this court as a sentence of 7 years has been imposed by the London Trial Court. Section 374 7 years have been passed either against him or against any other person convicted of the same crime in this court. Since the sentence is for 7 years and the appellant so and so the sole appellant, sole accused in this case. Therefore, appeal lies to, it has been rightly pointed out by the stamp reporter that the appeal lies to session judge, which is also session judge Kuchinda, है ना? वो assistant session judge Kuchinda होची trial court.
ADG court ଅଛି.
ADG court Kuchinda ADG court actually कि session judge court ही है, ହେଲା? ସେ appeal court pick କରି ସେ ଆକୁ register general କୁ ପଚାରିଲେ ବା register judicial କୁ ପଚାରିଲେ ସେମାନେ କହିଦେବେ, ହେଲା? ଯୋଉଗୁଡାକ magistrate କି assistant session judge conviction କରନ୍ତି ସେ appeal ଟା କୋଉଠି file ହୁଏ, ADG court ରେ file ହୁଏ ନା session judge ରେ file ହୁଏ, ସେଠୁ transfer ହେଇକି ADG court କୁ ଆସେ, ବୁଝିପାରିଲେ? ସେ ଅନୁଯାୟୀ ଜଣେଇବେ. And in view from the state of affairs, this JCR will be transferred to the concerned court. Hello? Okay. এটা কোন admission open করতে এরকম condition letter দেখুন so let's explore till item 19. But the petition was not activated. Confiscation.
Confiscation order
vehicle. So you apply instruction on this matter. So the hard she brought it to 480. Brought it to 480. Please record and apply instruction in the matter because of hard admit the land council for the state seeks some time to produce to obtain instruction in the matter. They put up this matter in the commencing from 22nd January 2024. He was accused in that case.
My lords.
The land bank and he was executed.
My lords.
The land council for the state shall also obtain instruction whether the state government intends to prefer any appeal against the judgment and order of acquittal or not. Two copy of the order be handed over to the land council for the state. Okay.
And item 20 will be taken up tomorrow.
No, we didn't say that bail matters will come though, so it will come next week in that was.
Good night. Item 6.
So
Item 6.
I see it next week as well.